Good morning, everybody, and welcome to the May 27th meeting or hearing by the Division of Oil, Gas, and Mining for the state of Utah. We have a relatively light agenda today compared to some of the times we do things. So we're going to start with our normal briefing session. So Mr. Thomas, if you would please go ahead and proceed.
Thank you, Chairman, members of the board. Thank you, Patty. There was a little bit of a logistical hiccup this morning, and I apologize for the minute and a half delay we had, but we're here now, 2.5 minutes. There are a few things I'd like to update the board on moving forward, and then we can have a discussion on each one. First of all, oil and gas bonding rules update. As you know, the comment period closed, I believe, at the end of April, and at this point there were no substantive comments that were acted on. The board did last time has provided some response to each of those comments, and those have been posted. Next month, I think the only thing left for the Oil and Gas Board is for us to bring the final version to the board next month and asking for it to be effective at the June meeting. If you have any questions, you can ask them now. I do also understand and support that there is always, for every board meeting, a general comment period. There may be comments offered today on these, but those comments will not be part of the official comment period as that is closed, just for clarity. So if you have any questions, I'm happy to discuss with you at this time.
Board members, have any questions? Okay, and for the audience, I think the first agenda item on the opportunity for public comment would be anybody that wants to talk about the bonding rules or provide the board any additional feedback. You'll be welcome to do that at that point. Okay.
Thank you, Chairman. The next item during the briefing session is progress on the division's portion of Senate Bill 254. I won't go into a long history of Senate Bill 254. It was a very comprehensive bill that came out of the 2026 session regarding the critical minerals industry, specifically the development of a critical mineral council. That council has been finalized by the governor's office as of last week. It's an 11-member council that is quite diverse. I am a vice chair. The division is a vice chair. There's co-chairs, which are the director of the governor's office of energy management or energy development, and senior legislator appointed by the governor. We are going to have a staffer, not under OGM, but with OED, to provide administrative support, essentially a secretary to that council. Those interviews were yesterday afternoon. We had 7 candidates. We have narrowed it down to 1 or 2. It was a good candidate pool, but that's going to be able to provide a significant amount of administrative support to the council. The purpose of the council is to develop and support and really create the vision for the critical mineral industry in Utah moving forward. It is not a regulatory council. This is frankly, a political and policy council that says, okay, this is how we're going to do it. It could involve consideration of economic incentives, environmental guidelines. What can we do to set Utah apart, not only in the mining of critical minerals, but more importantly, in the processing of those minerals? You all are probably familiar with the fact that processing capacity across all extractive industries is the bottleneck. We do a really good job of finding the resource, but how do we make it into the final metals or even the gasoline that we use in our cars, et cetera, et cetera? That's where the crux lies. Another nation on the planet that will be unnamed has a great business model there where they take global critical minerals and process it in their country and have really cornered the market. The U.S. wants to regain, and Utah specifically wants to regain that sovereignty and the security that comes from doing it in country. So the Critical Mineral Council, we will meet. Our first meeting is tentatively scheduled as soon as I have a affirmation on my calendar for the first week of June. It may be next week. Otherwise, it could be the week after that, but where we all come together and discuss next steps. There's a lot going on there, and I'm happy to answer any additional questions you may have.
You mentioned 5 or 6 people who were on the council, but said there were 11. What's the composition of the other
Oh, my goodness.
people?
I will have to get back to you on that. I haven't memorized that yet. I'm sorry.
Are they mineral people? Are they business people?
Yes, yes, yes.
Okay.
I know there are some legislators there. World Trade Center, Utah, for example, the Governor's Office of Economic Development, obviously oil, gas, and mining, the Office of Energy Development, the Utah Mining Association. I'm trying to go down a list. Unfortunately, or I say thankfully, the Utah Petroleum Association is not a member of that yet, and I don't think Ricky is really looking forward to wandering into that, but she won't. But anyhow, it's a diverse board, which brings a lot of. We tried to cover enough to where all viewpoints are considered, but you can imagine. I don't envy the person we're going to hire, who's going to have to manage 11 individuals. Just imagine me times 11. What a blast.
Who appointed them?
They are appointed by the governor's office,
Okay.
and also the Senate Bill 254 pointed out certain appointees, like the director of oil, gas, and mining, and OED.
Thank you.
All right, I'll get back to you with that list though quickly. Thank you.
And I guess I kind of see this almost as like developing a business unit that has all the different stakeholders in it. However, I assume it'll still go through the same regulatory process of oil, gas, and mining as far as permitting and such.
That's a good point, Chairman, Mr. Galecki. The permitting is isolated from the council. Permitting will still go through Department of Environmental Quality, Division of Oil and Gas and Mining, Division of Water, the State Engineer's Office. The permitting stays the same. This is essentially a policy and strategic council that comes together.
Okay, but I understand the policy and regulations, but do they have any scientists and engineers to make sure our policy is enlightened when they proceed?
It's a good question. There are representatives from the university system that are going to be on there. I do know that there is a science contingent. I just can't remember all of the members right now, Chairman. I apologize for that.
Okay, thank you. Any other questions by the board? Okay, next item then, Mr. Thomas.
Thank you, Chairman. Last week, many of you may know, Utah is a strong member of the Interstate Oil and Gas Compact Commission. We have annual meetings in the fall at different locations, and we have a dedicated business meeting in May in Oklahoma City where we come together to discuss the administrative of that. I am on a number of councils, as well as the vice chair for the Interstate IOGCC underneath Governor Dunleavy. And so Utah's engagement in that is pretty significant. Some updates from last week's meeting. There is significant interest in, one, continuing to garner federal support for orphaning, for funding abandoned oil and gas wells, P&Aing those wells. Thankfully, as you know, Utah is well in the lead considering production versus at-risk wells, which puts us in a great place. Other states are not so fortunate and need significant funding from the feds to help address that inventory. There was discussion on that. Interestingly, there was a lot of discussion on how to take the brine, whether it's in the Permian or Utah or in a number of basins, and develop that into useful culinary water sources. There's federal funding for that now, and several topics revolve around that. It's actually more urgent now because at about $100 a barrel for WTI, they can't find a place to get rid of the water. They've already filled most of the injection wells in Texas, and plus they have a lot of gas. What are they doing with that? They're actually paying municipalities to take their natural gas versus selling it, which has an interesting effect on the gas market locally in that area. But produced water, especially, is there's a lot of research and discussion going on that we talked about there. Different science, different technology and engineering to take that, let's say, 200,000 ppm saline brine that's coming out of the Permian especially, but nationwide, and turn it into culinary water. That's an ongoing discussion, and that was one of the interesting things we took away. And then there was a lot of administrative stuff, blah, 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 right? It's, of course, important, but not worth discussing. That's a good point. Earlier this year, the division was able to secure the initial grant of $5 million, and we are already moving forward to use some of that. We have P&A'd one well with that federal money, and last time I checked, we were in the process of two. I'll look quickly back to Megan and see.
We're currently plugging the second well.
We are currently plugging the second well, real-time update. So we are taking advantage of those funds.
That $5 million was dedicated to Utah, right?
That's correct.
Okay.
Yeah, each state that applied for that initial grant received it. Utah was the last state to apply for it, but we did make it in to the window, and we have received those funds.
Mr. Chair, your mic is muted.
Sorry. Okay, sorry. Any other questions on the IOGCC? And we'll go on to the mining compact.
The next item on the agenda, Mr. Chair, is other items.
IMCC?
Oh, IMCC. Excuse me so much. Our Deputy Director, Dana Dean, has come up to save the day.
Well, I just want to say that IMCC is, good morning, Mr. Chair and board members. The Interstate Mining Compact Commission is a similar organization in concept to the Oil and Gas Compact Commission, but you can see that it doesn't have that prestige right now because he totally forgot about it.
Man, this is brutal.
No, but there's good news. We're improving. So one of the problems has been that they also have a spring business meeting, and then they have a mid-year meeting. Those have, for some reason, been at the exact same time as IOGCC recently. I think they have contracts with hotels for this fall meeting and possibly next spring meetings that will still overlap, but beyond that, we are not going to overlap anymore, so that people like Mick, who are over both programs, can be involved in both compacts. But at this meeting, the biggest things we had, Lanny Erdos attended. He's the acting deputy secretary for Lands and Minerals in the Department of Interior, and he's also the director of the Office of Surface Mining, which oversees our coal and abandoned mine programs. He brought with him people from the BLM, and we talked about a lot of policy and things like that. It was a very good discussion. He did mention that the Office of Surface Mining is reorganizing, and they will announce that restructure after it happens. And he also announced that after they changed the 10-day notice rule last year, which was a good thing. They changed it so that you can't just write the state a 10-day notice based on a citizen's complaint without investigating. They had situations, thank goodness not in Utah, where someone would call up, and most times they were found to be unfounded with a complaint about a mine. I don't know what's wrong with this microphone. It keeps going in and out. But and then they would immediately just go write the state of 10-day notice saying that you're not implementing your program properly, without even going and looking at the mine or asking the state whether they had inspected that mine recently and taken enforcement action. So that can't happen anymore. They still take citizens' complaints very seriously, but they have to do an inspection and talk to the state before they can write a 10-day notice. On the heels of that, they're updating 3 big policies that they use for our oversight in the coal regulatory program, and they will give us a look at those before they finalize them. The big thing for the compact is the current president or executive director, or whatever they call it, is the person who runs the compact is retiring, and we have an opportunity to reshape how things are with the compact. We had, as a group, we interviewed 2 people. Mick was on a team that whittled the group down, the applicants down to 2. But all states had questions. We got to grill both candidates. The winning candidate who Utah voted for is Benny McCament. He's over all of the mining in the state of Ohio. He has been the past president of the National Abandoned Mine Association. He he has some really good ideas for how to make the Interstate Mining Compact Commission more valuable to the states, to cooperate with IOGCC instead of pretending like they don't exist and having meetings at the exact same time and keeping some directors from being able to participate in both. We're reorganizing the way that the staff gets raises. He's going to talk to every single state and see what their needs and wants are and create a new strategic plan. Things like that. So it's very exciting. Benny is excited to take on the job. Actually, we're just doing the job offer. I hope he's basically accepted it, but it hasn't been signed yet. But Benny will be great. His one thing that he'll need to learn is the people on Capitol Hill and the lobbying aspect. But we've talked about putting a lobbying firm on temporary retainer until he personally gets to know those people. And then, and everyone was satisfied with that. I'm satisfied with that. I think that'll be a good move forward. Benny really knows the needs of the states, and he sees what was not working with the commission and has really good ideas for moving forward. So those are the biggest things. We talked about a lot of policy and a lot of other things happened, but those are the biggest things.
Thank you very much. Okay, so next item is other, and I want to take the initiative here, Director Thomas. Yesterday around 5 o'clock, I received notification, ad hoc notification, that there was a blowout near Milford in a geothermal well. And I'd like to see if you could provide the board and us any kind of update on your knowledge of what's going on there.
Thank you, Chairman. Stand by while I see what I can find.
And while he's doing that, just so to be completely transparent, I received this notification from my nephew, who was down there doing electrical work as he was on the forge site, and looked over the fence and saw a blowout occurring and sent me a picture of what's a blowout. So go ahead, Mr. Thomas.
Thank you, Chairman, for that time. And before we get into that, I also want to apologize again for only reading the first 8 or 9 words of the prior topic. The IMCC is an excellent organization. We really appreciate Deputy Director Dean's participation and her gentle nudging as she walked up here. It duly noted. There was I would say, an above-ground midstream blowout on one of the geothermal drilling operations on Monday. This resulted in a breach about halfway up the string that was and may still be venting a significant amount of steam. The Fervo, the operator, decided, after evacuating the well site, obviously, and taking a safe distance and all safety precautions, which I've been told they have been, is simply letting the steam vent to depressurize before they move in. As we may discuss in a minute, geothermal operations in Utah, as you know, a little different from the majority of other states. It falls solely under the authority of the state engineer's office. I did reach out to the state engineer when you notified me of this, Chairman, and she affirmed that appropriate safety measures have been taken place and that the operator is in regular communication with their geothermal staff person at the Division of Water Rights underneath the state engineer. I'm sure there's going to be I would say a significant property damage involved with the drill string. Anytime you do something like that, there's things that need to be taken. I do not have any update or information yet if there's a root cause analysis of what caused that, and I don't have any additional information on that.
Okay. No injuries?
No, no injuries reported to my knowledge.
All right. Board, do you have any questions, Mr. Thomas? Okay, from personal experience, an event like this needs to, especially an unprecedented thing like this, needs to be thoroughly investigated. So, and I was involved in 3 root cause analysis in one of my prior positions. We do not have jurisdiction over geothermal wells, but DNR does. So I would strongly urge that you contact the folks up at DNR to initiate a root cause analysis immediately. If it is not done immediately, a lot of the evidence is destroyed, taken to the junkyard, missed. So I would suggest they need to issue a directive to FERVO to do a third-party root cause analysis immediately. Trying to do it inside the walls of DNR is not an appropriate thing. It has to be a third party.
Chairman, members of the board, I appreciate that. I have been in communication immediately once I heard about it with my supervisor, Deputy Commissioner Nathan Schweiback, and immediately after this meeting, I'll be traveling down south, where I'll be having significant time with Commissioner Ferry and all senior DNR staff. It's a coincidence, really. It doesn't have anything to do with this event,
Mm-hmm.
but we will discuss this topic today. And I will provide an update as quickly as possible with the outcome of those conversations.
Okay, great. Board, you got any other concerns about this blowout?
I'd just like to say, could you be sure to update us on the situation at next month's meeting? I don't know what'll happen between now and then, but if not before, could you give us an update on what's going on?
Definitely will. Again, in real time, I'll let the board. Actually, I'll let the chairman and co-chair know about the outcome is, and we'll communicate that via email or text, depending on the urgency of it, and then we'll provide a formal update next month. I do appreciate the board's position here. There has been a number of statutes and even rule updates, even recently, further establishing geothermal under the state engineer's office. Again, the state engineer is over water rights, and in the past and historically, geothermal involved water, hot water, steam that was conventionally extracted. So we appreciate the board's position there.
Go ahead, Ms. Sierra.
Just to follow up on that, I was kind of surprised when you noted that it was under the state engineer's office. In my previous experience, oil and gas, geothermal, everything had been together, leasing, permitting, because that's really where the technical expertise exists. So it was kind of interesting to note that state engineer has primacy rather than Division of Oil and Gas and Mining.
Yeah, I was just going to add to that, because it seems like all energy should be under the expertise of the oil, gas, and mining, because that's where it lies as opposed to the state engineer. So it'd be interesting to see what could be done, why it's not that way in our state.
Board, what do you think about asking Mr. Thomas to go ahead and form a little committee to review where that jurisdiction should lie? I mean, to me, high pressure, steam at 3,000 psi and 400 degrees Fahrenheit is not your normal thing's going to come out of the farm tap. So
I think that's a great idea.
I think that would be in order, because I think from a safety standpoint, technical experts, I think that's the way to go.
yeah, okay. Okay, so Mr. Thomas, if you would, within your own means and with the cooperation with DNR, look at where that jurisdiction should lie.
Thank you,
And,
Chairman.
and then maybe maybe give us a preliminary thoughts next month, and then we'll decide how far we want to push along on this.
Thank you, Chairman. I will initiate that and be prepared by next month's meeting. Again, it'll be a topic of discussion that I'll bring up today in our directors' interaction. And I do agree that it is all under DNR. Please understand that the staff within the Division of Water Rights, particularly Jim Goddard, is an incredibly skilled, experienced person. I cannot say enough about his expertise in this area. I just want to make sure that was on the record as well. And Teresa Wilhelmsen is a vigilant state engineer who earnestly supports the Division of Water Rights and water rights in Utah. That said, we will pull together some ideas and present to you next meeting in June.
Okay, thank you.
Could you tell me, is Mr. Goddard an engineer or a geologist or?
I think he's a geologist, which, as you know, is probably superior to an engineer in my book. But I may be off there. Matt, please strike that from the record, although he can't.
Thank you.
Sorry about that.
That's okay. Thank you.
Okay, thank you very much. Is there anything else in other that we need to cover before we go to next month's agenda?
Chairman, there's not.
Okay, go ahead. Then item 5.
Thank you. Again, next month's agenda is going to be Wednesday, June 24th at this time, 9 a.m. We have a pretty light agenda as of right now with only 4 docket items. That may grow.
Okay. All right. Okay. So anything else, Mr. Thomas?
No, thank you.
Board, any other questions before he steps back? Okay. So the next part of our meeting is the opportunity for public comment. I see there are several people here that probably want to talk about bonding. So let's, any people that want to talk about bonding, you're welcome to the microphone at this point in time. It's all yours, Mr. Peltz.
Great. Mr. Chair of the board, thank you so much for giving me a moment. I'm Adam Peltz, Senior Director and Lead Counsel at Environmental Defense Fund. I know that you're not adjudicating the bonding matter until next month, but I unfortunately won't be able to attend that hearing. So I wanted to come today and express my great appreciation for the process that you've all led over the past several years. I can't express enough how great it was to be able to spend quite a bit of time talking in a very civil and thoughtful and data-based way with the DNR staff and industry about this important issue. And I think that where you've landed, I'm sure you've all seen the comments that Environmental Defense Fund and others filed about issues in the rulemaking. Notwithstanding that, I think this is a very solid effort. I think it's very important that you're poised to take these steps and holding the riskiest operators in the state to account to ensure that they are able to plug their wells. I understand that you're all considering this is not the final word on this topic, and that, like any rule, once it's implemented, there will be things that need to be worked out, and that you may revisit it down the road sooner than later, and at which point you might consider some of the things that we've shared. But in the meantime, I think you should all be proud of the work that you've done and that your stakeholders have done, and that you could adopt this in good conscience, and we can all celebrate it. So thank you so much. That's what I have to share today.
Okay. Thank you, Mr. Peltz, for coming all the way from New York to share your thoughts. We certainly appreciate that devotion and the effort that Environmental Defense Fund placed on bonding.
Oh, I'll share one other thing, which is that your counterparts in New Mexico are grinding through a very similar rulemaking right now. In fact, they were the Oil Conservation Commission was intending to meet this week to discuss their bonding rulemaking, which is not entirely unlike yours. And they had to postpone a week because of illness. But they will be next week in a 4-day hearing. It'll just be the 3 commissioners talking about each aspect of the rule for 4 days, which I think should be a scintillating live stream. And they may finalize the rule as soon as the end of next week, or it could be next month. But so it's likely that you and New Mexico will simultaneously come out with bonding reform, each specified to your own state. But it does speak to a realization in this region that this is a serious issue and it's good to get out ahead of it. And so wanted to make sure that you had the heads up on that activity in New Mexico.
Oh, thank you. Thank you for that information. It's good that Dogum has stayed on top of the orphan well thing, and it's not that big of a problem yet, but we want to keep that.
Yes, you're early in your development cycle compared to some neighboring states, so now is the time to get on this.
Yeah, okay.
Are there any other states that are undergoing bonding reform?
So Texas is in the middle of a rulemaking around inactive wells. That was required by the passage of SB 1150 last year, which limited how long wells can stay idle in that state to 15 years, and the Railroad Commission has till the end of this year to complete that rulemaking. They are allowed to touch bonding, and in fact, one of the rulemakings specifically is around inactive wells on transfer, where a bonding solution would be appropriate. They may not end up doing that. But there was an interim charge in the legislature, and the legislature will be having hearings later this year to talk about that question. Oklahoma passed bonding reform last year. They increased the size of their blanket bonds for larger operators, and that's been going through some rulemaking processes. And Louisiana's is standing up a natural resource trust authority as part of an overhaul of their agency last year, and that agency is tasked with financial assurance and collecting monies from operators for their orphan well fund. Things are bad in Louisiana. They've added 1,500 orphan wells in the last year, and it's only getting worse from there.
Yeah.
Oh, and that's onshore.
It's a mix of onshore and then the state offshore. So the state offshore wells cost like 10 times more than the onshore wells do. And of course, because of sea level rise, more of the onshore wells are becoming offshore wells every day. And so they have a whole other set of urgent problems that you all in Utah are lucky to not have.
Thank you.
Okay, thank you very much. Anybody else have anything to address with Mr. Peltz? Okay, thank you.
Great, thank you.
Okay, is there anyone else that wants to speak about bonding before we move on? Seeing none, okay. Now that this is an opportunity for public comment by anybody in the audience that wishes to come forward, so we'll open it up for public comment at this point in time. Any item. Okay. All right, so just for transparency, this is my wife, Victoria Walker, and as she's coming in to talk about, I know what she's going to be talking about, so I am going to recuse myself, hand the chairmanship over to former chairperson, and step down. So, and I will actually recuse myself for probably the first 3 items so that we get all the way through the topic at hand,
Okay.
so that we don't have be coming up, go down, that sort of thing. So,
Okay.
Madam Chair, if you want to take over.
Oh, you want me to move over there?
Well, or we can, that way you're next to council,
Okay.
just to make it nice and safe.
Okay. See if I remember how to do this. Okay. Let me just get settled here for a minute. Okay, could you please introduce yourself and the item you want to discuss?
Yes, my name is Victoria Walker. I go by Vicky Walker, and I am here to discuss WEM's request for division response and notice of non-opposition to request for agency action, cause number 132-86. Is that enough of an explanation of what I
thank
would
you.
like to discuss? First of all, I'd like to thank John Rogers and Patty for last week's notice. And I'd also like to say that my husband, Alan Walker, who indicated that he was the chairman, had no idea that I was going to listen to that meeting, and also no idea that I was going to speak at that meeting.
Could I interrupt you for just a second?
Absolutely.
Gary Wright would like to make a comment
Thank
before we
you.
get started.
Thank you. I don't know if I should call you Madam Chair or I'm a little confused right now, but I represent the hearing examiner in this proceeding. There's going to be a formal report and counsel is here. I'm wondering if it makes more sense to have this discussion during that report with counsel present for.
On this particular item?
Yes, it's one of the hearing examiner items.
Are you comfortable with that? I recognize, like, for standing in the case, so it's whatever you're comfortable with.
I think it would make more sense to have everyone available to discuss the matter together,
Okay.
Okay.
but that's just a suggestion.
Okay, I think these next items are,
So I'm tabled for now.
for-
Is that right?
for just a moment.
All right.
I think you can stay where you are because I think these items that we have coming up have been withdrawn.
All right.
And so your item will actually be the first one we discuss.
All right.
Okay.
Thanks, Gary.
Let's go on to the first item on our docket, which is docket number 2026-022, cause number 470-27. In the matter of the request for agency action of KODA GNB LLC for an order partially amending the board's orders entered in causes number 173-1, 173-2, 173-20, and 173-23 to modify the stratigraphic definition of the spaced interval as pertaining only to the drilling units established thereunder, comprised of the south half, section 33, north half and south half respectively of section 34, and the north half and south half respectively of section 36, Township 8 South, Range 20 East, SLM, and South Half, Section 31, South Half, Section 32, Township 8 South, Range 21 East, SLM, and the North Half of Section 4, Township 9 South, Range 20 East, SLM, Uinta County. This matter has been withdrawn and dismissed without prejudice. We're going to move on to item number 2. Let's see. Okay. Item number 2, docket number 2026-021, cause number 132-87, in the matter of the request for agency action of WEM Operating LLC for an order pooling all interests, including the compulsory pooling of all interests of non-consenting and unknown owners within the 1,280-acre substantial equivalent overlapping drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River and Wasatch formations comprised of sections 34, 35, 4 South, 4 West, USM, Duchesne County, Utah. This matter has been withdrawn and dismissed without prejudice. Now we're moving on to this order. Shall we have Mrs. Walker stay where she is, or?
Whatever you want.
I think that's fine. I think that's fine. Are you okay with that, Mr. Chicken?
Absolutely.
Okay.
Sorry.
We're moving on now to docket item number 3. Docket number 2026-018, cause number 132-86. In the matter of the request for agency action of WEM Operating LLC for an order pooling all interests, including the compulsory pooling of all interests of non-consenting and unknown owners within the 1,280-acre or substantial equivalent overlapping drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River and Wasatch formations comprised of sections 23 and 24, 4 South, 4 West, USM, Duchesne County, Utah. This matter has been continued from the April 15, 2026 hearing examiner proceedings, and we will commence with appearance of counsel.
Brent Chicken, Steptoe and Johnson, PLLC, on behalf of WAM Operating LLC.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Assistant Attorney General Gary White on behalf of the hearing examiner John Rogers.
Okay. Let's see, are we going to begin with Mr. Chicken or Mr. Rogers? All right.
Good morning, Acting Chair Garrison and members of the board. My name is John Rogers. I'm Environmental Manager with the Division of Oil, Gas, and Mining, and I've acted as hearing examiner in this proceeding as directed by the board for this matter just described by Ms. Garrison. The proceeding was held with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah on Wednesday, May 20th, 2026. At the beginning of the hearing, no member of the public was present in person or online. There is a minor issue concerning participation that I'll address later. It has to do with Ms. Walker. We'll get to that later in my report. During the proceeding, 2 sworn declarations and exhibits were admitted into evidence on behalf of WEM Operating. Mr. Alexander Yang, a land manager, and Mr. Trevor Fields, a reservoir engineer, both of WEM Operating, presented declarations and reviewed by the division and me prior to the hearing. The attorneys just introduced were present at the hearing and represented their respective clients. Both of WEM's witnesses are accepted by the division and me as expert witnesses in their field of work in this matter, and both witnesses printed live testimony at the hearing. The division filed a response of notice of non-opposition to the request for agency action dated May 11, 2026. At the conclusion of the hearing, Mr. Haynes, on behalf of the division, stated support for the request for agency action. The Division of Oil, Gas, and Mining and I had an opportunity to cross-examine the witnesses present on the behalf of WEM. Questions were introduced concerning notification, risk penalty, heirship, and all issues were answered at the hearing, in my opinion. Midway through the hearing, Ms. Vicki Walker contacted us by telephone. At the time, we allowed her to speak on the phone for everyone present. She claimed to be a descendant of Eva May Casper Tice and had some preliminary work to support that claim. After discussion between all parties, it was determined there was no probate completed on the Tice estate. WEM offered to work with Ms. Walker if the probate was completed, but for now, the Tice interest was compulsory pooled. After reviewing the request for agency action, the sworn declarations and admitted exhibits, and hearing live testimony presented at the hearing, I found and recommended the following. WEM provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pool. Proper notice for the hearing examiner proceeding was also provided. Those owners that failed to participate timely and should therefore be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. The 100%/300% non-consent penalty is fair and justified given the economic and geological conditions present in the connection with the drilling of these wells. I therefore recommend that 100/300% non-consent penalty be imposed as requested. WEM has met its burden of proof and otherwise satisfied all legal requirements to compulsory pool the non-consenting parties. For your interest, WEM's working interest is 93.59%. The non-operating working interest is 5.81. Therefore, the compulsory pooled interest is 0.60%. WEM's counsel, Mr. Chicken, prepared the proposed findings of fact, conclusions of law, and an order granting its request for agency action. Both the division I reviewed and approved the proposed order. I then executed the proposed order filed with the board's legal assistant. I would take any questions now at this time.
Board, do you have questions? Division?
Nope, no questions, Mr. Rock.
Thank you. Please proceed.
Okay, I assume at this time we'd like to hear from Ms. Walker, since she's come in, and see what her opinion is and present her case before you.
Thank you. Ms. Walker?
Thank you. My request is that the board consider removing Eva May Tice, and Ferris Casper from the list of non-locatable persons. It's also my request that in the case you do not do that, that you remove the 300% penalty from my family. I've been in contact with WEM. They know that we have in the process doing probate. I presented them with evidence, I presented them with alternatives to doing a formal determination of heirship. I come from a real estate background. Title companies will accept a determination of heirship without an order. WEM is under their legal ability to say no, they are requiring that. As Mr. Rogers stated, the percentage is low. So the risk is low. So that is one of the reasons I requested that WEM take that risk and accept a determination of heirship without the order from the court. They refused to do that. Also, probate does not require that you have a formal probate, but an informal probate if the estate is less than $100,000. I informed WEM that my mother had passed. I gave them a copy of an affidavit that is acceptable under Utah probate. They refused that and said that they required a formal probate because mineral rights were considered real property, not personal property. I accepted that, probated my mother's estate, and I am the personal representative of my mother's estate. My mother has her interest via May Tice's estate. May Tice died intestate. She had no children. She, according to Utah probate, it then falls to her nieces and nephews. There are 22 of those, which we have been working with to get the determination of heirship done through Duchesne County. There have been phone calls made to WEM, customer relations, that were not returned. Mr. Yang has been very responsive whenever I have contacted him. In February of this year, he and I had an extended conversation. They are aware of how to contact me for May Estate's estate. They are also aware that I have been working on the estate. Therefore, I do not agree that we are considered unlocatable and non-consenting. Let me address non-consenting. WEM came to my family in 2024. My mother was still alive at that point. We negotiated a lease with her and WEM. We negotiated a royalty rate with WEM. At that point, WEM, I believe, either had not yet drilled or had one well. My mother was alive for one more year. There were no payments made. When she had her stroke and came to live with me, I contacted WEM to see if there were funds. I was told that those funds were very small, but that they were put in an escrow account. That's when one of the conversations with WEM began. I feel that my family is locatable. I feel that, yes, Mr. Rogers, you are correct. The probate is not yet perfected. But I am moving forward, making progress, and have had conversations recently as February. And so I don't think it's appropriate. So I'm requesting that you not appoint us with the penalty and that you remove us from that page.
Let me ask just a couple of questions here. When you first started, you mentioned Eva Tice,
Yes.
and then I didn't get the first name, Casper.
In 2024, when I was contacted by WEM, I asked for copies of the mineral searches. I was given 5 800-page mineral searches that were done in 2023. Those mineral searches showed the mineral estate came from Francis Brooks. Francis Brooks was married to Agnes Casper, who was the oldest sister. Eva May Casper and Ferris Casper were orphaned as small children. They went to live with Agnes and Francis Brooks. I bring that out because for the first year, from 24 to 25, I spent time, energy, money looking for and doing a determination of heirship for Francis Brooks, because the mineral searches showed that his estate was not probated. I found that probate. I went to Davis County, found it. Subsequent to that, I asked for what needed to be done to perfect his estate in Duchesne County, and I found that WEM had actually helped and had already recorded in 2024 deeds from Francis Brooks' estate into the way the probate had been had stated the will had stated the way the interest should have come down. So WEM was aware of that in 2024. The document that they gave to me didn't reflect that. And last week, when I asked for updated title reports and was refused them, that concerned me, because from a title background, when you foreclose out someone's interest, you must provide them with an updated title policy so you can make sure that every person who has a recorded interest in that real estate is noticed. Well, if they're not willing to give me, or have not done, updated mineral searches, how do we know that everyone was noticed properly? I know that I didn't receive notice of this.
And then what is the relationship between Eva Tice and May Tice?
Eva May Tice is her name.
Oh, Eva
She
May
goes
Tice.
by May Tice. She always
Okay.
went by May Tice. But her full name was Eva May Casper Tice.
And you said Eva May Tice executed a lease a couple years ago?
Dicey Casper executed the lease. My mother is Dicey Casper. I am her personal representative, and she was May Tice's niece.
Boy, this gets confusing.
Yeah.
But your interest is not covered by that lease?
It is now, because I'm a personal representative, but they are trying to remove my interest and charge me a 300% penalty by saying that she is a non-consenting or unlocatable person.
And what exactly are the names of the families that you're representing that you want removed, if we consider that?
Eva May Casper Tice and Ferris Casper.
And Ferris Casper, okay.
And I don't know why Ferris Casper is there anyway, because the WEM helped his son record a personal representative's deed. When you record a deed in a recorder's office, they tell you who came to record that. And it says, for Wasatch Energy Management, LLC. So that document was filed by WEM.
Ask her what date she made the representative of the estate.
When were you appointed the representative for the estate?
It's been very recent. It is... May 5th, 2026, probate case number 263-700-121.
Okay. Okay. Board, do you have any questions of this? Okay. Do you have anything else, Mrs. Walker, before we move over to WEM?
I'm willing to work with them. I don't
Okay.
blame them. I realize they have a lot of people that they're trying to work with. If they didn't do the update of the mineral search and notify all the parties, I think that's something they need to correct and should be totally disallowed. But I look at this at like, this is probably, I don't know if your position is to make sure that the public is taken care of. I don't know.
What percentage of the total do these two estates represent?
I do not know that.
Okay. Okay.
We have been told by WHAM, I believe it's 0.71%. Is that right, you guys? I don't know.
Okay.
It's a small percentage.
Okay.
It's a small percentage. Warren Zevon has a song. It's called Lawyers, Guns, and Money. My family has no money. My family has no lawyers, but they have guns. And the reason they have guns is because they take care of their sheep and they take care of their cattle, but they don't have money. And so this has fallen on me, and I'm trying to handle 22 cousins, and I'm making progress. I'm asking that they continue, and you allow me to continue to make progress. Because this, even though this is a small percentage, this is money to them. You know, and they do wheat out in their fields. I went there this weekend over Memorial Day, and they're out there in the farms. They don't have time to be coming to a family meeting.
Okay. Could we move over now and hear the WEM side of the story?
Thank you, Madam Chair.
Do we need to swear in your witness or not?
Well, let me make a comment, and if you want to hear from the witness, you can.
Okay.
Everything I'm going to talk about was given as part of sworn testimony or in the declarations at last week's examiner hearing. The decedent in this that we're discussing here, Eva Mae Casper Tice, she passed away a long time ago. Her estate has not been probated. There's no final probate order for her estate, nor is there a personal representative's deed conveying this interest, which is a 0.007974% interest in this well in DSU, to any of her heirs and devisees, which would include all of the individuals, including Miss Walker. Utah's a uniform probate code state. In order to establish marketable record title to ownership of an interest, you need both. You need a probate order and a personal representative's conveyance. An affidavit of heirship does not do that. That's a private document where somebody says, here's the people I can remember that are, family members of the decedent. A determination of heirship also does not do that. That is a court saying, here are Bob's heirs and devisees at law. It does not transfer the interest. Accordingly, although WEM remains willing to work with Miss Walker and her family, we have a break in the chain of title of ownership of this interest that is decades old that has not been fixed. You cannot fix the break in title between Eva Mae Casper Tice and the folks Miss Walker is working with right now, including the estate for which she is PR, by probating later estates. The problem is decades ago between the record title owner, Eva Mae Casper Tice, and her various nieces, nephews. I think Miss Walker said that she died without issue. And she died intestate. You can do, and the difference between a formal and informal probate in Utah courts. An informal probate is done through the clerk, but it still has notice to creditors, a PR appointed, inventories have to be filed, all of that type of stuff. A formal probate is litigation. So you almost only ever see a formal probate when there is a fight over a decedent's assets. So if Eva Mae Casper Tice's estate were to be informally probated and result in an order of, a probate order of intestacy, the appointment of a personal representative, and a personal representative's deed placed of record to her heirs and devisees, WEM would be able to credit this interest. But without that, what we are being asked to do is take it on faith that rather than a court confirming who Eva Mae Casper Tice's heirs and devisees are, we are going to listen to and follow and rely upon what the family has done. There's probably literally tens of thousands of families in the state of Utah that would love for that same thing to happen. And it's probably in most cases the right outcome. A lot of times the family knows better than anybody else, but we also don't know that people didn't have a will in a drawer that left everything to the United Way or left everything to the single cousin that took care of them in their final days. We have to, as a company, make sure that we are paying the right people, that we are giving the right, giving the interest and crediting the right interest to the right people who actually own it. Because it's well established, if you pay royalties to somebody that doesn't own it, good luck getting your royalties back. So you end up setting a precedent where you could end up as an operator paying twice, 3 times, 4 times on the same interest because you're not relying on probate. And so that is the reason that the estate of Eva Mae Casper Tice is listed as a unlocatable, because that estate is not probated and there is not a PR to provide notice to. Accordingly, we publish notice as required by the statutes and rules of this board, providing notice of the filing of the RAA and a notice of an opportunity to participate specifically to the estate of Eva Mae Casper Tice, which is the legal way of providing notice to decedents' estates that don't have personal representatives. And so that is why, although WIM is willing to work with, and if you would like to speak to Mr. Yang and swear him in, he can tell you that that WEM has taken protective leases from various different members of the decedent's estate of Eva Mae Casper Tice. In fact, if you look at the pooling order, WEM has been successful between filing this RAA and getting to last week's hearing. We identified 8, 9 other probate estates. We already had protective leases from those folks, and we removed them from compulsory pooling. We just don't have a way to remove Eva Mae Casper Tice from compulsory pooling when, if you go to the county records, her name is on the last deed in the record chain of title to this interest.
So you have taken protective leases from some of the 22 heirs?
I believe so. I would need you to swear in and ask Mr. Yang those questions if you'd like that information.
Yeah, I would. Do you want to swear him in, or you want me to do it? Would you please stand and raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please state your name and position.
Yes. My name is Alexander Yan. I am a land manager for WIM Operating.
Thank you. And so the question was, have you taken protective leases from some of the 22 heirs?
Yes.
Do you know how many of them have leased?
Without looking into the record, I'm not 100% sure, but I know that we have contacted majority of the heirs that were alive at the time. I think we started doing this in 2022, 2023. For all those people who we have contacted who were willing to sign a protective lease, we have received one from them.
Do you have any information from any of your searching that there are other potential Eva Mae Tice heirs out there that are not disclosed among these 22? Do you believe that, to your knowledge right now, that would constitute the legal heirs?
So, Madam Chair, in my opinion, I would say the legal error would be very small.
Mm-hmm.
However, recognize that when you say the number 22, it's very hard to gauge who exactly, just the number and not two names. And
right. Yeah. Right. So are either the affidavit or the determination filed of record in the county records? Do you know? Are those just internal documents?
So are you referring to, could you clarify which affidavit or documents you're referring to?
Can I address Mrs. Walker? Are either of those, did you participate in getting those affidavit and or determination signed?
Well, let me clarify one thing. I proposed to do a determination of heirship and WEM without the order. So when you do a determination of heirship for a probate with the court, you do the determination of heirs, which is like a determination of heirship. So all of the heirs are noticed and the notice is posted, et cetera, et cetera. The court then goes in and gives you an order saying these are the heirs. And yes, a personal representative is appointed, and then yes, you do a deed. And that personal representative could act on that order. So that is what WEM requested from me when I suggested they take a determination of heirship. I accepted that was their position. I did not say that I would not do that. I certainly gave them reason why I felt like there was little risk in taking a determination of heirship. A, with the percentage being so small, their financial risk was small. And B, with the number of parties that we were working with, they could not tell me what the royalties on the wells would be, and I understand that. But did it make sense to incur the legal costs? And so, I gave them pushback, sure. To me, to my family, the advantage would be to have them take the determination of heirship, but they chose not to do that. So I must go get an order. So your question, is the determination of heirship of record? Not yet. Will it be when the probate is done? Yes. Determination of heirship.
And back to Mr. Chicken. Has WEM had any contact with Mrs. Walker since May 5th when she was appointed PR?
Yes, she appeared at the hearing last week telephonically.
And you've provided her with all of the information and an opportunity. I guess they'd be covered by the lease, so there wouldn't.
Well, but there's a disconnect here. The disconnect is the person that owns this interest that we're talking about, this 0.007974% interest in the Duchesne County records, is Eva Mae Casper Tice, who has been deceased for decades.
Okay.
You cannot just skip over that to her heirs and devisees, particularly when there's 22 or more of them, and they're all nieces and nephews too. If you ever look at the intestate succession statute, it's kind of weird. Like, the first person your assets go to is your spouse. After that, they go to your parents, even if you're 90. And if they're not around anymore, so it kind of goes back and forth. This is why, this is why Utah law requires a personal representative's deed to transfer that interest of record from the decedent to the decedent's heirs. And I can promise you, if there was a PR deed provided to WEM, they would credit it accordingly. The problem here is that that has not happened, and what WEM is being asked to do is, as Ms. Walker noted, take a risk on what everybody seems to agree is a small risk and credit the interests of all of those heirs without that PR deed. And the problem for a company like WEM or 4Point or Oventive, any of the other operators here is, and as I'm sure the board has seen and Mr. Rogers and Mr. Baza will tell you, this is the majority of what gets pooled. These old probates that have never been done, and then what happens is a precedent gets set. All of a sudden, you have a situation where you have 30, 40 decedents' estates in a single DSU that collectively owns less than 0.5% of the working interest, but none of it has been probated. And so the company cannot be sure that they are paying the actual owners. And so it's very hard to ask a company to take that risk, because the situation that applies here applies in every single pooling this board has ever approved. Every single one of them, where you have a decedent's estate, the operator has a good idea of who the heirs, devisees, and successors are, but there's no confirmation of that by a court or by a conveyance. And that to me is this is a legal issue, that we are being asked to credit an interest in parties that nobody in this room can stand up and swear own that interest.
What's the royalty rate on the Eva May Tice lease? Would that be the governing lease?
There is no lease for this interest because the interest is owned by a decedent. So the lease would be the 0.007974, based on what Ms. Walker is telling us, is split 22 ways. And we have no idea, by the way, of knowing whether that split is equal or not, because there are no probate orders or conveyances confirming that split. So even if you divide it evenly, 0.007974 across 22 folks, you're now into the thousandths decimal place for what each one of those parties would own. And if they've signed a lease, that lease is a protective lease, but there is no royalty being paid on that lease. What is being paid is the average acreage weighted landowner's royalty.
And what is that percent?
That was, give me 1 second. It's in this order here. 18.394455%. That is what is being paid to every single unleased decedent's estate listed as our non-consenting parties.
Has this well been drilled?
It has. And so that money is being put into a suspense account pending probates and conveyances.
Has it been on for quite a while, or is it a brand new well?
2 years, I think.
2 years.
I'll let him answer.
Plus or-
I'm just, yeah.
Plus or minus?
I believe the well has been online for more than a year.
Okay.
Oh, here it is. First produced November 21st, 2024. And so those funds, that acreage weighted royalty, is being paid for this estate and for every other estate into a suspense account, and pending probates and PR deeds that meet Utah legal requirements. And assuming that gets done, the money gets released. If it doesn't, the money gets turned over to unclaimed property in the name of the estate.
And roughly, what's the daily production from that well?
I have no idea. I think we would be guessing. I don't know if Mr. Yang wants to hazard a guess, but
do you have any idea, Mr. Yang?
I don't.
Okay. Board, do you have questions, Ms. Sierra?
What would be the harm, now that we know that Mrs. Walker is going through this process to establish heirship, or whatever the terminology is, and just wait until she's concluded her process before you take the proposed action that you want today?
Well, I think I mean, to the interest, there is no harm. That acreage-weighted royalty is going into a suspense account. It's been in there since November 2024, and it's going to be in there if it takes a week or 2 more years to finish that probate. That money will be there. Any money that got turned over to unclaimed property, the state of Utah, the Secretary of State, would ask for the same exact documentation. They would say, I'm holding money for Eva Mae Casper Tice. Prove to me that you are an heir or devotee of Eva Mae Casper Tice.
But you're asking for a 300% penalty and non-consent person. What would be the harm of suspending
Well,
that
in this case, that penalty is not attributable to the royalty. The royalty, because it's an unleased interest, the royalty just gets paid at 18.399955% for that entire interest. But that's the other thing, is that we don't know if we had that money sitting here in a pile. We don't know all of the people that are entitled to a piece of that money without this probate and the ones that Ms. Walker is currently working on.
If you are actively pursuing getting leases on these things, can you hold that money indefinitely and not turn it over to unclaimed properties, or is there a time frame?
There is a time frame, but I would have to ask WEM if it's willing to do that, because there's also a penalty for not turning over unclaimed property. So
Even
it's,
if you have ongoing negotiations with people?
I think there may be an out for that.
Yeah.
If that's the case. So,
Okay.
but that's our bigger concern is that this particular situation is the situation of every decedent's estate that ever gets pooled. We don't know. We know what that person's interest is because they are the record owner, the decedent, but we don't know who is entitled to it after that decedent has died unless a court and a conveyance tell us that. And it creates a very slippery, messy slope if, companies do the best they can to try and gauge through things like affidavits of heirship and things, and take protective leases so that if the estate or if that interest is ultimately legally transferred and recognized in those people that have signed the leases, then those leases are treated as valid since day one, since under Utah Probate Code, you become the owner of a decedent's interest as a devotee. You become the owner of the equitable title at the date of death. The legal title comes through the probate. So and the statute says, you are the owner as of the date of death, subject to administration. And that probating is what connects those 2 dots for that payor and those payees. This is a fundamental principle of why pooling exists and why we publish notice and why we have, we're very careful to list out all of the parties, their status as, are you an unleased owner that, just didn't respond? Are you a decedent, the owner from a decedent's estate? That's why the pooling statute exists and the notice requirements exist, is so that you can draw a line in the sand and say, from and after this point, here's what the ownership is, and here are the people that we need to notice. And I'll share with the board, WEM actually had another pooling request on deck for the hearing last week. We withdrew it. And the reason we withdrew it was because we had found and identified so many other decedents' estates in between filing the RAA and that hearing date that we we just decided it would be better to withdraw the pooling and then refile it without those decedents' estates being listed in there, because quite frankly, it's just better to have somebody sign a lease and pay them their royalty every month from an accounting standpoint. There is a lot of accounting that goes into keeping track of all of these decedents' estates' interests. And so I think I would speak for any operator in saying that if we could get a lease from that operator, or that operator would agree to, or that person would agree to participate their unleased minerals, that's what every operator in this state wants. You don't want to have long lists of pooled parties that are decedents' estates that you can't find. And you might be able to look at obituaries, and we do lots of research, tons of research, to identify who these people are. At the end of the day, it is incumbent upon those heirs and devisees to ensure that the law of the state of Utah, when a person dies, is followed. And sometimes it's a tough call, because when you do have this small interest, and if you take 0.007974 and split that 22 ways, we are literally in the realm of your royalties on an annual basis aren't over $100, so you pay them once a year for each one of those 22 people.
How much money is currently in suspense for this interest?
I would have to ask Mr. Yang, and I don't know if he would know how much is in suspense for this particular
You don't know how
interest.
much is in suspense for this?
I'll have to refer to my records, and at this time, no.
Thank you.
May I respond?
Yes.
Mr. Chicken, may I direct this question to Mr. Chicken? No.
No.
All right. If they entered into a lease with family members and they do not remove the names of the family members from this filing, are the people with whom they've entered into leases still going to be paid their royalties?
That's a legal question I'm not sure I can answer.
I think that's a good question to
Yeah.
ask an attorney
Yeah.
who represents you.
I don't.
at this point.
Yeah, I was just going to say, we're going to move this along a little bit. Let's
Okay.
go back to the division. Do you have any, oh, I'm sorry, looking at the wrong table.
I think maybe there's a little bit of a misunderstanding of what we're doing here in a compulsory pooling action. Mr. Chickens laid it out quite well why we perform these compulsory poolings. Ms. Walker, I know you have concerns as to this penalty that everyone keeps talking about, but in reality, I don't know about your protective leases that you've taken or what's going to happen there, but in reality, you will still receive a royalty. That penalties is not going to play until their request after payout. Then if you want to come back into the well, you're going to get paid. They're not taking the revenue stream, production proceeds away from you in this proceeding. This is set up for exactly the situation we have here, where record title cannot go any further than the estates, and these operators want to pool all their interest in the unit. So I know you have concerns about this penalty that they keep talking about, but monetarily wise, outside of you taking a lease that is greater than this royalty that will be awarded, there's not a lot of difference in money that will be seen there. In fact, when you get compulsory pooled, if you want to come back into the well later, you have that opportunity. If you're in a lease, you don't have that opportunity. So there's different mechanisms here, but I don't think this is the adverse situation that maybe it appears to be.
Even if this money were paid to unclaimed property, if they had not leased, they would be entitled to go back to day one of production. Is that true? And collect their funds?
Once that money will always be the
It'll be
person who
there.
owns it, and when you can prove that you have ownership to that money, it will be there.
Okay. Mr. Chicken, do you have any further comments?
I don't. I think our position is fairly clear. This money is sitting there for the listed decedent's estate, and if you can meet the legal requirements to show that you are now the owner of that, whether 1 or 22 people, then you'll be entitled to that money. But like I said, even if you set it over to unclaimed property, believe me when I tell you, the unclaimed property folks are not, they're going to say, this is who we have this money for, prove that you are an heir or a devizee, and you're not going to be able to show that by showing that you are an heir or devizee of somebody further down that chain of title. They're going to want to see heirship from that decedent. And in this case, I appreciate how difficult this is, and I can tell you, I get calls all the time from people such as yourself in a similar situation that are saying, I need help. And what I find out is I am talking to Bob, whose dad is dead and used to own the interest, and whose grandfather is dead and used to own the interest, and whose great-grandfather is the last record title holder. And Bob wants me to get that money to him. And when I explain to him the number of probates that we have to do to get that money to him, the cost that's going to be associated with it, and the difficulties of connecting all of those dots, it is a difficult situation, because you could spend thousands and thousands of dollars on lawyers, and ultimately the interests are so small that it would take 50 years to recover that cost.
Board, do you have any further comments?
A couple,
Okay.
real quick. So like you just said, as far as probate, does it make economic sense? I assume you'll be able to provide the pumping, what dollars are actually talking about to Ms. Walker if she requests it.
I think we can do that. We can check our records, and I'll ask Mr. Yang to get in touch with her.
Because my understanding through all of it is that the probate is necessary to understand who gets the money. She can do the probate at any time. I mean, if they choose to do that. What's not clear to me is the funds are being there. As far as the participation penalty, where does that fall into place?
So it doesn't in this case, because it's an unleased interest. So the penalty is applicable for a risk compensation. In this case, it's an unleased interest, and they therefore get paid their proportionate share of, the average acreage weighted landowner's royalty.
Okay.
It's just there's no personal representative to pay that money to. And as soon as there is one, that one PR would have the ability to knock at WM's door and say, I'd like you to release whatever suspended funds you have for this interest. And trust me, I think WM would be happy to say, here you go. And now the duty to properly pay that total out to all of the heirs and devisees shifts from the duty of the operator to the fiduciary duty of the personal representative to do that. And so if we had even a PR, I think would be enough for, if you show me a court order appointing a personal representative for the estate of Eva Mae Casper Tice, then you can release to that personal representative, and they would be responsible to dole it out to all of Eva Mae Tice's various heirs and devisees.
Does that 0.79%, is that their share of the weighted average royalty?
No, that's the ownership of
That's their
Eva Mae.
mineral
At
interest.
0.007974
Okay.
is the proportionately reduced to acreage and mineral ownership in the entire drilling
Okay.
unit. So that's what the estate of Eva Mae Casper Tice owns
Thank
in
you.
this well, the Lee well, and would own in all other wells in that drilling and spacing unit. And so that's why I was saying that if that interest is indeed, if there's 22 heirs and devisees, that number gets divided by 22. And if you're going to be out into the 10,000ths spot, I think, 4 or 5 decimals over, once that's split up. But believe me, rather than trying to figure it out, if there was a PR, and this is true of any decedent's estate that would be listed in any pooling, if there is a PR and a live person that is responsible for that estate and that interest, that person can be paid. And we would prefer to pay that person rather than having to then sit and figure out what percentage of that goes to nope, you're Eva May's PR. Here's Eva May's 0.7974 reduced share of that, acreage weighted royalty. Distribute it however you would like to, PR.
Okay. Board, do you have any further questions? Any further questions from the hearing examiner section, or? Mr. Haynes, do you have any further comments?
Nope, no additional comments.
Board, we should probably discuss this for a minute. I think we're going to recuse, and we'll be back try to be back in 15 minutes.
Okay.
Thank you.
Thank you.
1.
We're back on the record. We've discussed the matter, and I believe we're ready for a motion.
I make a motion to approve the hearing examiner's findings on the petition's request for agency action, and will note that Ms. Walker can still proceed with obtaining the necessary documentation in order to collect any money interest being held and is noted by WEM.
Thank you. Do I have a second?
I'll second.
It's been moved and seconded. All in favor, please say aye.
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 Any opposed? Hearing none, the motion passes. Thank you.
Thank you, board. You want this?
Do we need any orders or anything with this?
They had it printed out, so they're
Oh.
gonna get a
You're on
signature
top of
since
this.
the hearing examiner's here. Yep, and then that will come to you guys, the right signature as well.
Do I need to sign these, or can Al sign them?
How are you?
We'll just strike.
Just-
Strike his name and write her name.
Yeah, yeah. Initial it.
Well, years ago, not since this, recent years, but I had an old buddy was for the longest time. His last run was going to do a perlite mine down in Milford, and it was always just a little bit, and then they haven't been there for a while.
Okay.
I'm excited.
Yeah,
Then I need to, I'm trying to set some things up with the autonomous line down by, is it by Web?
that sounds about right. Yeah, for your students to get them all out.
Yeah, it's supposed to be completely autonomous. I mean, it can't be a very large scale.
Yeah.
Mr. Walker. I don't care either.
Yeah, so, I guess you're setting it up. I mean, school's all out now, isn't it? Or is
Yeah,
it?
this is, so we're trying to do industry outreach right now to where we support them and, and then in the fall, we would take students there. Yeah, students are either on internship programs.
Yeah, right.
They're incoming freshmen. We have 18 incoming freshmen. Which when I first arrived 2 years ago, that was the entire class size. We're up to about 60 now.
Okay. Yeah, I remember, let's say decades ago, it was huge,
COVID destroyed it.
Yeah.
COVID just destroyed that.
Are you guys good if we just start calling the next one while we work on this stuff? Are you?
Mr. Rogers, are you ready then at this point in time? Matt, I think we're ready.
Sounds good. We are on the record. We're ready to go.
Okay.
Go ahead.
Yes, we're going to go ahead and proceed with agenda item number 4. This is docket number 2026-24, cause number 132-88. In the matter of the request for agency action of SM Energy Company for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners in the 2 Frank wells identified herein within a 2,560 acre or substantially equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River, Wasatch, Colton formations, comprised of section 28, 29, 32, and 33, Township 2 South, Range 1 West, USM, Duchesne County, Utah. And the board will consider the findings of fact and conclusions of law recommended by the hearing examiner for the proceeding, from the proceedings on May 20th, 2006. Go ahead.
Okay, thank
Take
you.
appearances.
Oh, you want to do that first? Okay, go ahead.
Mitch Mayo of Lear & Lear PLLC on behalf of the petitioner SM Energy Company.
Okay.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Assistant Attorney General Gary White on behalf of the hearing examiner John Rogers.
Okay, thank you. Go ahead and proceed, Mr. White.
Good morning, Chairman Walker and members of the board. I'm an environmental manager with the Division of Oil, Gas, and Mining, and I act as a hearing examiner in this proceeding as directed by the board. A hearing examiner proceeding was conducted on this matter on Wednesday, May 20th, 2026, as described by Chairman Walker. The proceeding was held with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. No member of the public participated in the hearing. During the proceeding, 2 sworn declarations and exhibits were admitted into evidence from Mr. Levi Dean, senior landman, and Mr. Brad Peterson, Utah Region Asset Manager, both of SM Energy. Both of SM Energy's witnesses were accepted by the division as expert witnesses in their field of work in this matter. They also presented live testimony at the hearing. On May 11th, 2026, the division filed a notice of non-opposition response to SM Energy's resources request for agency action, expressing non-opposition to the granting of the request. At the conclusion of the hearing, Mr. Haynes, on behalf of the division, stated support for the request for agency action. No other party filed a response to the request for agency action or appeared or participated in the hearing, and therefore failed to reply in a timely manner or participate at the hearing after given proper notice. The Division of Oil, Gas, and Mining and I had an opportunity to cross-examine the witnesses presented on behalf of SM Energy. After reviewing the request for agency action, the sworn declarations, and admitted exhibits, and hearing the live testimony presented at the hearing, I recommend the following. SM Energy Resources provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pull. Proper notice for the hearing examiner proceedings was also provided. Those compulsory pulled owners failed to timely participate and should therefore be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable and should therefore be adopted to govern the future dealings between the parties. The request of 100%/300% non-consent penalty is fair and justified, given the economic and geological conditions present in a connection with drilling of these wells. I therefore recommend that 100% and 300% non-consent penalty be imposed. SM Energy has met its burden of proof and otherwise satisfied all legal requirements to compulsory pull the non-consenting parties. For your interest, the working interest owners percentage for SM Energy is 78.99%. Combined with those who agreed to participate and otherwise voluntarily join the unit equals 99.41%. The request to seek compulsory pulled approximately 0.59 of the mineral owners. The average weighted land fee royalty interest is approximately 17.38. SM's Energy Council, Mr. Mayo, prepared the proposed finding of fact, conclusions of law, and order granting its request for agency action. Both the division I reviewed and approved the proposed order. I then executed the proposed order and filed it with the board's legal assistant. It now should be ready for the board's review and execution. I'll take any questions at this time.
Board, any questions of Mr. Rogers? Okay. Let's go ahead and proceed then, Mr. Mayo.
Nothing to add, just appreciate the efforts by the division and staff at the hearing examiner process.
Okay. Division?
Yeah, the division concurs with Mr. Rogers' statements and has also approved of the proposed order. Thank you.
Okay. Board, any further questions or anything like that? Any need to deliberate? Okay, go ahead. Does anybody care to make a motion?
I'll make a motion that we approve the RRA as presented by the hearing officer.
Okay, any second? It's been moved and seconded that we approve the recommendations of the hearing officer. All those in favor say aye.
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 Any opposed? Oh, it's unanimous. So can you go ahead and prepare the order? I guess it's already prepared.
I think Mr. Mayo's already.
Mayo's
prepared
got, Mr. Mayo's got it. Okay,
It's not, and it's all approved from this side.
been approved. Okay.
While he starts reading the next one, I'll walk over and hand him this one for you.
Okay. All right. So that takes care of agenda item number 4. Agenda item number 5 is here. There it is. Okay, good. Okay, so agenda item number 5, I think we'll probably have the same people involved here. Okay, this is docket number 2026-025, cause number 132-89, in the matter of the request for agency action of SM Energy Company for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners in the 10 Frank and Tank wells identified herein, within a 1,280 acre or substantially equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River, Wasatch, Colton formations, comprised of Section 28 and 33, Township 2, South, Range 1 West, USM, Duchesne County, Utah. The board will consider the findings of fact and conclusions of law recommended by the hearing examiner from the proceeding on May 20th, 2026. Let's take appearances. Mr. White.
Assistant Attorney General Gary White on behalf of the hearing examiner John Rogers.
Division.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Okay, Mr. Mayo.
Yeah, thank you. Mitch Mayo, Lear & Lear PLLC on behalf of the petitioner, SM Energy Company.
Okay, go ahead and proceed.
Okay, thank you. Good morning, Chairman Walker and members of the board. My name is John Rogers, and I am Environmental Manager with the Division of Oil, Gas, and Mining. I acted as a hearing examiner in this proceeding as directed by this board. The proceeding was conducted on this matter on Wednesday, May 20th, 2026. For the matter as described by Chairman Walker just now. The proceeding was held with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. No member of the public participated in the hearing. During the proceeding, 2 sworn declarations and exhibits were admitted into evidence from Mr. Levi Dean, Senior Landman, and Mr. Brad Peterson, Utah Region Asset Manager, both from SM Energy. Both of SM Energy's witnesses were accepted by the division and me as expert witnesses in their field of work for this matter. They also presented live testimony. On May 11th, 2026, the division filed a notice of non-opposition response to SM Energy's request for agency action, expressing non-opposition to the granting of the request. At the conclusion of the hearing, Mr. Haynes, on behalf of the division, stated support for the request for agency action. No other party filed a response to the RAA or appeared or participated in the hearing, and therefore failed to reply timely or participate at the hearing after giving proper notice. The Division of Oil, Gas, and Mining, I had the opportunity to cross-examine the witnesses presented on behalf of SM Energy. After reviewing the request for agency action, the sworn declarations, and admitted exhibits, and hearing live testimony presented at the hearing, I found and recommended the following. SM Energy Resources provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pool. Proper notice for the hearing examiner's proceeding was also provided. Those compulsory pooled owners failed to timely participate and therefore should be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. The requested 100%/300% non-consent penalty is fair and justified, given the economic and geological conditions present in the connection with drilling of these wells. I therefore recommend the 300% non-consent penalty be imposed. SM Energy has met its burden of proof and otherwise satisfied all legal requirements to compulsory pool the non-consenting parties. For your interest, SM Energy has approximately 0.85% working interest, combined with those who have agreed to participate or otherwise voluntarily join the unit, approximately 99.84%. The request to compulsorily pool approximately 0.16% of the mineral owners. The average weighted fee of landowner royalty interest is approximately 17.95%. SM Energy's counsel, Mr. Mayo, prepared the proposed findings of fact, conclusion of law, and order granting the request for agency action. Both the division and I have reviewed and approved the proposed order. I then executed the proposed order and filed it with the board's legal assistant. It should now be ready for the board's review and execution. Take any questions at this time if you have some.
Board, any questions? I have a quick question. When you say 100%/300%, what's the 100% applied to?
It's 100% of the operating costs and 100% of the surface equipment.
Mm-hmm.
The 300% applies to the
drilling.
Drilling of the well and the original investment in the well.
Okay, all right. And let me make sure I wrote this down right. The compulsory pooled is 0.16%?
Yeah, let me just double check. That's how I remember it. But you think I guess put these on?
That sounds accurate to me, Mr. Walker.
Yep, 0.16. Okay.
0. Point,
Okay, 0.16. So
yeah,
16.
0.16. Okay. Okay. Stuck with math here, so I always want the 0 first. All right, good. Mr. Mayo, anything else?
No, again, just to thank everyone for the time to get these done at the hearing examiner.
Okay, division?
Yeah, again, the division concurs with Mr. Rogers' comments and has approved of the proposed order that we have. Thank you.
Board, any questions of any of the parties? Anyone might want to make a motion?
I move that we approve the hearing examiner's findings for the requests for agency action.
Second?
I'll second.
Okay, it's been moved and seconded that we approve the request for agency action. Okay. All those in favor say aye.
Aye.
All any opposed? It's unanimous. So go ahead and, I guess you've got the order already. So while you're getting that shuffled around, I will read item number 6.
Thank you.
Okay, agenda item number 6 is docket number 2026-019, cause number 470-26, in the matter of the request for agency action of Uinta Wax Operating, LLC, for an order, 1, establishing 4 overlapping stand-up 2,560-acre drilling unit boundary well units, and 2, partially amending the board's order in cause number 139-84, 139-135, 139-143, and 139-154 to A, allow 32 wells in the 1,280 acre drilling units, and B, to cover the Green River and Wasatch formations, and C, to set uniform boundary and interwell setback, all in section 17 to 20 and sections 28 to 33, Township 2 South, Range 1 East, USM, and sections 25 and 26, Township 2 South, Range 1 West, USM, all in Uinta County. Let's take appearances.
Mark Burkhart and Madeline Whittier, both at Dorsey and Whitney, on behalf of Uinta Wax Operating, LLC.
Thank you. Division?
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Okay. And your witness is Peter Pankey. Okay. All right. Go ahead, proceed.
Thank you. Board Chair, members of the board, appearing virtually on behalf of Uinta Wax Operating, LLC, are Joe Judd, attorney at Uinta Wax, who will be testifying on land matters, Shay Atkins, Executive Vice President of Uinta Wax LLC, who will be testifying on matters pertaining to geology, and Kayleen Bridwell, Senior Engineer, ESG Advisor, Regulatory Manager at UNOWACS LLC, who will be testifying on matters pertaining to reservoir engineering. UNOWACS LLC shares duties with petitioner UNOWACS Operating LLC. Board Chair, I ask that these three witnesses be sworn in at this time.
Please raise your right hand. Do you swear to the evidence you're about to present is truth, whole truth, and nothing but the truth, so help you God?
Yes. Yes.
Okay, thank you. They're sworn in.
All right. Thank you. The resumes of all three witnesses were collectively submitted as Exhibit A. If asked, each would confirm the information reflected in those resumes is true and correct. Mr. Judd will be testifying as a fact witness only. Mr. Atkins has previously been recognized by the board as an expert in geology, and Ms. Bridwell has previously been recognized by the board as an expert in reservoir engineering. Based on their resumes and the prior recognition by the board, and presuming the division has no objection, we request that Mr. Atkins be recognized as an expert in geology and Ms. Bridwell be recognized as an expert in reservoir engineering for purposes of this hearing.
No objections from the division.
Board, any questions on that? Okay, so granted.
Thank you, Board Chair. And as is the usual practice, we'll be moving for admission of the exhibits at the end of our presentation. Related to that, and before we begin, I do want to confirm that the board has received copies of substitute exhibits R and S that will be filed on May 14th pursuant to the board's order allowing the substitute exhibits.
Yes, we've got those.
Perfect, thank you. And just a quick roadmap where we're headed today. You'll notice that there's two of us up here, and I know that you know Ms. Whittier. I will give an introduction, and then I will examine Mr. Judd and Mr. Atkins, and then I'll turn the time over to Ms. Whittier, who will examine Ms. Bridwell, and then finish things up.
Okay, thank you.
Members of the board, through its request for agency action, UNOWACS seeks to establish 4 overlapping stand-up 2560-acre drilling unit boundary well drilling units for the Green River and Wasatch formations for sections 25 and 36 of Township 2 South, Range 1 West, and sections 17 through 20 and 28 through 33 of Township 2 South, Range 1 East. 2, to allow 32 wells in the existing 1280-acre drilling units. 3, expand the covered interval to include the Green River and Wasatch formations. And 4, set uniform boundary and inner well setbacks for the lands subject to this request. The lands are currently subject to the board's order entered in cause number 139-84 and 139-135, establishing 640-acre drilling units, and cause numbers 139-143 and 139-154, establishing overlapping 1280-acre drilling units. Copies of all 4 of these orders were collectively submitted as Exhibit B in this matter. UNOWACS is seeking to amend these orders to allow the 32 wells to be drilled in the existing 1280-acre drilling units, to expand the existing interval to include the full Green River and Wasatch formations instead of just the lower Green River and Wasatch formations, to provide uniform boundary setbacks of 100 feet on the north and south or hill toe and 330 feet to the east and west. With respect to the stacked or wine rack configurations, long lateral horizontal wells drilled to different stratigraphic intervals, to include a 330-foot lateral inner well setback, but with no inner well setbacks as long as the stacked intervals are at least 100 feet apart in vertical distance. And finally, to remove inner well setbacks between existing wells and newly drilled long lateral horizontal wells within the drilling units. Otherwise, these existing orders will remain in effect. UNOWACS is also seeking to drill up to 6 stacked drilling unit boundary wells on each of the 4 drilling unit boundary well drilling units, which wells can be drilled anywhere within the 330 feet on either side of the boundary line between the 2 1,280-acre drilling units comprising the drilling unit boundary well drilling unit with a setback of 100 feet from the north-south or hill toe of the unit boundary. The requested 2560-acre drilling unit boundary well drilling units have been requested and approved throughout the Uinta Basin. Likewise, the requested setbacks are consistent with the board's recently issued orders in cause numbers 470-20 and 130-39. Additionally, the request to adjust the current orders to cover the subject formations has been requested and approved in similar circumstances, including in cause number 470-20. The board has jurisdiction over this matter pursuant to Utah Code Annotated 40-6-53B and 40-6-6. Notice was sent by certified mail to all legally protected interest owners in the affected lands, including the Ute Indian Tribe Ute Distribution Corporation and the Utah State Office and Vernal Field Office of the BLM. The mailings were sent to parties at their last address of record as disclosed by the public records and as supplemented by UNA Wax's searches. The record also reflects that notice was duly published in the UNA Basin Standard, Vernal Express, and Salt Lake Tribune. On May 11th, the division filed a response in non-opposition. Additionally, on May 11th, Mr. Dan Maldonado and Ms. Sherry Land each filed an objection to the request for agency action. UNA Wax met with both parties to discuss and resolve any concerns, and accordingly, the parties withdrew their respective objections on May 14th, 2026. As a result, this matter is uncontested. Mr. Marlon E. Hall also submitted a comment letter lodging a general objection as a landowner and as a conservationist for wildlife. Other than the division's response, the withdrawn objections, and the comment letter, no other objections or responses have been received, and no other party has made an appearance here today before the board. With that, with that introduction, I'll commence my examination of Mr. Judd. Mr. Judd, would you please state your name and business address for the record?
Joe Judd, 6000 Western Place, Suite 1000. That's in Fort Worth, Texas, 76107.
Thank you. What is your current position with UNA Wax, and how does it relate to the lands at issue today?
I'm an attorney for UNA Wax, and I have been kind of appointed over the lands that are subject to this request in a land capacity.
Thank you. Would you please state for the record the corporate and bonding status of UNA Wax Operating, LLC?
UNA Wax Operating is a Delaware limited liability company. It's in good standing. Principal place of business is here in Fort Worth. It's duly authorized to conduct business in the state of Utah, and it's fully bonded with the relevant state and federal agencies. And it acts as the designated operator on behalf of UNA Wax, LLC.
Thank you. I'm going to direct your attention to exhibits C through I. Do you recognize these exhibits, and were they prepared by you or under your supervision?
Yes.
We're going to take some of these exhibits out of order. We've put them in the presentation in the order that we're going to present them, but if we jump around a little bit, I promise we will get to all of the exhibits. Okay. So turning now to Exhibit C, can you please explain to the board what this exhibit shows?
This is a general locator map identifying where the lands subject to this request are located, predominantly there in the southwest quarter of 2 South 1 East, just to the west of Fort Duchesne.
And now turning to Exhibit D, would you please explain to the board what this shows?
This is also a map of the lands that are subject to this request, but identifying the long lateral, vertical, and directional existing wells within those lands.
And how many wells are there?
There are 27 producing long lateral wells and 7 vertical or directional wells inside the lands.
Okay, and those are producing wells, correct?
Yes.
And are there any wells that are in process? Currently
There's
being drilled?
approximately 8 long lateral horizontal wells in process.
Terrific. Thank you. Turning to exhibit, what did we move? D? G. Thank you. We're out of order. Turning to exhibit G, can you please explain to the board what this shows?
This map depicts the 2560 DSUs that are subject to this request. There's 4 of them. You can see 3 of them there outlined in a solid blue outline. And then the 4th is comprising sections 29, 30, 31, and 32 with a dashed blue outline also colored there in gray.
Thank you. Turning now to Exhibit H, can you please explain to the board what this shows? F, I'm sorry. Turning now to
F.
Exhibit F. I'm jumping
Okay.
around.
Exhibit F depicts the boundary line, the 2560 boundary line well in relation to the two adjacent 1,280 acre DSUs, and it also shows the 330-foot east-west setbacks in relation to that boundary well and the DSU, those 1280 DSUs.
Thank you. Now turning to Exhibit H, can you please explain to the board what this shows?
Yes, this shows or depicts the other equivalent spacing orders that are adjacent to or near the land subject to this request. And you can see in green, you can see cause number 470-20, which has similar spacing setbacks with 100-foot north-south, 330-foot east-west, and it also allows for boundary wells. You can see in blue, just to the south of these lands, cause number 470-04, which also has the same 100-foot north-south setbacks, 330-foot east-west setbacks, and also allows for 2560 boundary wells. And then just to the east of that in purple, you can see 470-07, which has similar setbacks at 100 feet north-south, 330 feet east-west, and also with the 2560 boundary wells. So you can see all of the orders in the area with the similar or identical setback requests that we've requested here.
Thank you. Turning now to Exhibit I, can you please explain to the board what this shows?
This shows the existing spacing orders that are that these lands are subject to, and there's two orders there. There's 139-143 depicted in green, and then 139-154 depicted in blue. And these establish 640 and overlapping stand-up 1,280 acre DSUs.
Thank you. Turning now finally to Exhibit E, can you please explain to the board what this shows?
This shows the notification area, so it includes the land subject to this request in addition to all of the offsetting lands or the offsetting DSUs. All of these would be 1,280 acre DSUs that are adjacent to these lands, and depicts the area of all the relative interest owners that we notified.
And within this area, who was notice sent to?
All legally protected interest owners within the red outline.
Okay. I'm now going to ask you to turn your attention to the certificate of service. You should have a copy of that in front of you, and it should be in the materials. This is the pleading that was prepared by my office with information that you supplied. Do you recognize the names and addresses that are shown on this certificate of service?
Yes.
And who are those parties?
Those are all the legally protected interest owners that we did notify that are within the red outline on the prior exhibit.
And how were those names and addresses derived?
We pulled those names from the public records in the county, both online and at the courthouse. Also a combination of our own in-house records, which included title opinions, and then other sources, just, you know, any means possible, including Google.
Terrific. Board Chair, with that, that concludes my examination of Mr. Judd.
Mr. Haynes?
Yeah, just a quick question. So we looked at, you have the notification area up, we looked at your certificate of service. Could you just confirm that you have not received any additional objections or comments related to this request?
No, we have not.
All right, thank you. The division has no further questions for Mr. Judd.
Okay. Board, do you have any questions for Mr. Judd? Not seeing any. Go ahead and proceed.
Okay, thank you. With that, I'll commence my examination of Shay Atkins.
All right.
There you are. Mr. Atkins, please state your name and business address for the record.
Yeah, my name is Shay Atkins, 6000 Western Place, Suite 100 in Fort Worth, Texas, 76107.
And what is your current position with UNOWACS, and how does it relate to the lands and the requested issue today?
Yeah, my current position is Executive Vice President and expert in Uinta Basin geology.
It's a good segue. I just wanted to remind that Mr. Atkins has been recognized as an expert in geology for purposes of today's hearing. I'm now going to show you what's been marked as exhibits J, K, and L. Do you recognize these exhibits?
Yes, I do.
And were they prepared by you or under your supervision?
Yes.
All right, starting with Exhibit J, would you please explain what this exhibit shows?
Yeah, Exhibit J is a type log for the application lands. This is the BAB 6-24-2-1E that exist in the immediate area just to the immediate east of the application lands. This log covers the entire Green River and Wasatch formations, specifically called out here from the Mahogany through the North Horn, which represents the base of the Wasatch.
And what formations or intervals will the amended 640, 1280, and newly created 2560 acre drilling units cover?
That'll be the Green River and Wasatch formations.
Moving now to Exhibit K, would you please explain to the board what this shows?
Yeah, Exhibit K is a cross-section on the right side of the slide with a locator map on the left side going from west to east, with the type log shown on the previous slide being that on the far right of the cross-section. So the main takeaway from this is the lateral continuity, consistent thickness, and rock that represents good horizontal targets across this immediate area.
Thank you. And now turning to the last exhibit, last of your exhibits, Exhibit L, would you please explain what this shows?
Yeah, Exhibit L, there's a couple of key takeaways from this. First, the map area illustrates, and the red outline is the application lands. You'll see some blue arrows and some purple arrows that represent different principal stress directions, data points that we have through this area. Purple represents microseismic data, blue represents image log and sonic log data, all showing a good trend and a good understanding of what the maximum principal stress direction is relative to the application lands. And that being an average orientation of 83 degrees. Above the map is a table that illustrates for two areas, microseismic, through microseismic, the fracture half lengths. And you can see each of those, one in orange and one in blue, and what those averages are for those data points, the average of those data points being 246 feet. And so those two pieces of data, 246 feet, fracture half length, and at an orientation of 83 degrees for the maximum principal stress direction will be carried forward in future slides under Ms. Bridwell's testimony.
Thank you. So in your expert opinion, are the Green River and Wasatch formations one common source of supply?
Yes.
Is it also your expert opinion that the uniformity of the Green River and Wasatch formations requested to be spaced through the area make long lateral horizontal wells attractive here?
Yes.
And is it your expert opinion that the fractional orientation supports a stand-up drilling unit orientation?
Yes.
Board Chair, that concludes my examination of Mr. Atkins.
Okay, division?
Thank you. Just a couple clarifications for Mr. Atkins. Could we see Exhibit J, please? Just want to get clarified. The request asks for the full Green River. I just want to make sure we're just talking to the top of the mahogany, correct? Are those different things, or is the top of mahogany the top of the Green River, or is there some extra strata in there?
Sure. No, the Green River does extend above the mahogany. I think it may be exhibited on the next slide too. There's a cross section to go all the way to the top of the. I guess not. It goes above to the mahogany bench. Sorry, but yeah, the request is for the full Green River to be able to zoom in and to see. For clarification on that slide, was focused on the mahogany through the North Horn. That represents a significant interval. But the request is for the entire Green River formation.
So in the RAA, there is a stratigraphic definition. Does that need to be altered, or can we? Let's see. Oh, yeah. I don't know if you have that stratigraphic definition with you.
I don't have the physical RAA in front of me. I could confer with council to look at that.
Yeah, I'd just like to get that clarified, just so we make sure we have the exact definition that we want in the request.
I could read this to you, Mr. Atkins, if that's helpful, or I can try and send it to you if we have a moment. What would be most useful?
Yeah, if we can take a moment and just confer on that.
Yeah, if we can take a brief break.
Okay. We're off the record for a few minutes.
We're back. We're back live.
Do we have Mr. Atkins here?
Yep. Yes, I'm here.
Okay, I just can't see you, so.
Okay.
Oh, there you are. Do you want to respond to the question?
Yeah, so I guess that was I was misspoken on my part. The definition is as defined here on the slide, from the top of the mahogany bench through the top of the North Horn.
Okay, thank you. Then
yeah,
we're good with what's in the RA.
Correct.
Okay, great.
Thank you.
So let's go to Exhibit L. So this gives us the interpreted regional stress in areas. We'd heard previously that there'd been I can't remember the exact number, 26 wells, something around there, drilled in the requested area right now. Is there any regional stress data in those wells that are being drilled?
No, what's shown on the map is the extent of the data that UNTWAX has in this area. We have not collected any additional data, however, have been the performance of the wells that has been drilled in the application lands has been satisfactory, indicating that it is drilled in the proper direction and supports the data that we have.
Okay. And as to this, these new zones that are being added, these new depths, looking in the Mahogany, are there any wells currently drilled in the Mahogany?
Not within the application lands.
Okay. Are you aware of wells drilled in surrounding areas in the Mahogany?
There are wells drilled in surrounding areas and what would be classified as the new zone in the Mahogany.
Okay. And we have the average fracture orientation indicated as 83 degrees, which is it's used in a future exhibit as you indicated when it relates to setbacks. So my question to you would be, would that average fracture orientation be accurate as to these new depths that we're adding to the formation definitions?
Yes.
Okay. All right. Thank you, Mr. Atkins. No additional questions.
Thank you.
Thank you.
Board, any questions for Mr. Atkins? Go ahead and proceed.
But before we move on, I just wanted to clarify that it was not my intent to change the interval. I went to law school. One of my worst grades was geology. So when I say the full Green River, we're not changing that at all. So I apologize for any confusion that I caused.
But it's on the record that it's to the top of the Mahogany.
Yeah, correct.
Okay, got it.
All right, thank you. I will now commence my examination of Kayleen Bridwell. And we have her on the screen. So, Ms. Bridwell, could you please state your name and business address for the record?
We can't hear you, Ms. Bridwell.
Yes, I had to find the mute button. I apologize. I'm Kayleen Bridwell at 6000 Western Place, Suite 1000 in Fort Worth, Texas, 76107.
And what is your current position with UNOAX, and how does it relate to the lands at issue here today?
I am a senior engineer and environmental regulatory advisor, supervisor. I oversee the subject area we're talking about today.
Thank you. And similar to Mr. Adkins, I'd just remind the board that Ms. Bridwell has been recognized as an expert in reservoir engineering for the purposes of this hearing. Yes. So we will now move to exhibits M through Q. Oh, it's okay. And substitute exhibits R and S. Do you recognize these exhibits, and were these prepared by you or under your supervision?
Yes.
Thank you. Starting with exhibit M, would you please explain what this shows?
Yes, this is a representation of the current spacing in the area and the unrecovered resource at the 300-foot heel toe and the 560-foot east-west setbacks.
Thank you. And if we move to exhibit N,
Mm-hmm.
would you please explain what this shows?
Yes, this slide uses the microseismic data shown in exhibit L that to show our average fracture orientation of 83 degrees and 246 feet of fracture half length. The calculations give you an X direction distance and a Y direction distance of 238 feet in the X and 61 feet in the Y. The graphic on the left here focuses on the Y direction, and this is really showing the 61 feet is well within our proposed 100-foot heel toe setback.
Great. And would you please explain now what exhibit O shows?
Yes, so similar to the slide we just talked about, but this one focuses on the X direction. It's showing that the 238 feet is well within the proposed 330 east-west setbacks. We have a similar visual as the previous slide showing improved recovery from a reduction to a 330 east-west setback while still protecting relative rights.
Thank you. Moving to Exhibit P. Could you please explain to the board what this exhibit shows?
Yes, so this is just reiterating the position of the application lands with respect to the nearby PVT samples that we've used for our drainage calculation that we're going to show on the next slide.
Great. Exhibit Q. Could you please explain what this shows?
Yes, this is a calculation that utilizes the Hale and Evers equation, which is a methodology previously recognized by this board and division as appropriate. If you will look at the B sub F column, this shows about 95 feet after a period of a decade in drainage in the Y direction, and showing that just after 10 years, we would start draining a little bit beyond that, but it's very minimal even at 40 years.
And is this relatively standard through the development area?
Yes.
Thank you. Now we will turn to substitute Exhibit R. Could you please explain what this shows and its significance to the request?
Yes. So this exhibit is showing the economic benefits of our proposed request. This shows incremental gains from utilizing longer laterals, and our estimate that this gives us around almost 14,000 additional barrels of oil per well. We also did some present value calculations showing just over $800,000 of additional revenue per well. And then the next few points are as it addresses severance tax and those impacts, and that's showing approximately $37,000 per well as it pertains to present value. And if you do that for 32 wells, you will get nearly $1.2 million of additional revenue to the state.
Thank you. And finally, we'll turn to substitute Exhibit S. And could you please explain what this shows?
Yes, so this is a gun barrel diagram showing typical development set up with the 32 long lateral horizontal wells. We wanted to add this exhibit to show how we see the development going forward in these proposed DSUs.
Thank you, Ms. Birdwell. And is it your expert opinion that the requested approach is appropriate and will maximize resource recovery, prevent waste, and protect correlative rights?
Yes.
Mr. Chairman, that concludes my examination of Ms. Birdwell.
Division?
Thank you. The division has no questions for Ms. Birdwell.
Okay, board, do you have any questions? No questions by the board. So.
Thank you. You're making it very easy on me.
Okay, let me ask a question. Go back to Exhibit L, if you would. There I had a fraction and half length of 86 feet, I think. Up there? No. Never mind. You have the same. Never mind. Okay.
Thanks.
I withdraw my question. It's made easy.
Thank you. Well, with that and all the questions, that actually concludes our presentation in chief. So I would now request admission of our exhibits A through Q and substitute exhibits R and S.
Division, any issues with that?
No objections.
So admitted?
Great. With that, I'll reserve some closing comments until after the division has made its presentation.
Division, proceed.
Yeah, the division just has a brief statement. The division reviewed the RAA and the associated exhibits along with the subsequent filings in this matter. Based on review of these filings and the testimony here today, the division has no objections to approving this request.
Okay. Board, any questions of the division? Okay, seeing none, let's go ahead and...
Thank you. I will try to conclude quickly. So I just wanted to go back over a summary of the relief we're requesting from the board today. Again, UNOAX is requesting 4 things of the board. UNOAX seeks to establish 4 overlapping stand-up 2560-acre drilling unit boundary well drilling units for the Green River and Wasatch formations for the subject lands. UNOAX seeks to allow 32 wells in the 1280-acre drilling units, cover the Green River and Wasatch formations, and set uniform boundary and inner well setbacks. In so doing, UNOAX asks the board to amend the board's orders entered in cause numbers 13984, 139-135, 139-143, and 139-154 to provide uniform boundary setbacks of 100 feet on the north-south and 330 feet to the east-west. With respect to the stacked configuration, long lateral horizontal wells drilled to different stratigraphic intervals provide a 330-foot lateral interwell setback, but with no interwell setbacks as long as the stacked laterals are at least 100 feet apart in vertical distance. Remove interwell setbacks between existing wells and newly drilled long lateral horizontal wells, and allow a total of 32 wells to be drilled in these existing 640 and 1280 acre drilling units. Lastly, UNOAX is seeking the ability to drill up to 6 stacked drilling unit boundary wells on each of the 4 drilling unit boundary well drilling units that can be drilled anywhere within 330 feet on either side of the boundary line between the 2 1280 acre drilling units comprising the drilling unit boundary well drilling unit with a setback of 100 feet from the north-south of the unit boundary. UNOAX believes its presentation today sufficiently establishes that granting its request will be in furtherance of the public policies of this state, constitutes orderly and consistent development, minimizes surface impacts to individuals residing in the area, and is just and reasonable under the circumstances. Therefore, UNOAX thanks the board for its time today and for allowing its witnesses to participate remotely, and would ask that the board approve the request as submitted.
Okay, thank you. Okay, board, is there any need to deliberate this? Not seeing any interest in deliberating. Anyone want to make a motion?
I move that we approve the request for agency action.
Second.
Okay, there's been a motion to approve the request for agency action, and second. All those in favor say aye.
Aye.
Any opposed? It's unanimous. So if you could go ahead and prepare the order.
We'll prepare that and submit it.
Okay, thank you very much.
Thank you.
Okay, yeah. Okay, so I've got some travel coming up, so if you could get it done sometime next week, that would be great. Don't need it tomorrow, but the week after, yeah. Thank you. Okay, we are down to one last item, and I think rather than take a lunch break, let's just drive through. Anybody have an objection to that, or need a break? Okay. Yes, sir. Go ahead. I will go ahead and read it into the record as you're setting up there, Mr. McDonald. If that's okay. Okay, so the last item is docket number 2026-023, cause number 470-28, in the matter of the request for agency action of Uinta Wax Operating, LLC, for an order 1, partially amending the board's orders entered in cause number 131-151, 470-03, and 470-24 to modify the stratigraphic definition of the spaced interval. 2, establishing overlapping 3 sectional stand-up vertical drilling units for the production of oil, gas, and associated hydrocarbons from the Green River and Wasatch formations through extra long lateral horizontal wells. And 3, establishing associated 6 sectional stand-up / vertical drilling units for the production of oil, gas, and associated hydrocarbons from the Green River and Wasatch formations through extra long lateral horizontal drilling unit boundary wells, all within Township 3 South, Range 1 East, USM, Uinta County, Utah. We'll take appearances.
Fred McDonald of counsel with Lear & Lear PLLC on behalf of the petitioner UNOX Operating.
Okay, thank you. Division?
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Okay. Okay, we'll just wait a second and let us know when you're ready, Mr. McDonald.
Ready, Mr. Chairman.
Okay. Go ahead and proceed, Mr. McDonald.
Thank you, Mr. Chairman. With me today, appearing virtually pursuant to the board's May 14th order, are Ms. Whitney Womack, the landman of Uinta Wax LLC, Robert Horner, who's the senior geologist of Uinta Wax LLC, and Mr. Taylor Cotton, who's the reservoir engineer of Uinta Wax LLC. All of these parties share duties with the petitioner. And Mr. Chairman, I would ask that they be sworn in at this time.
Okay, and Mr. Atkins is not going to be appearing today?
He's not, yes.
So please raise your right hand. Do you swear that what you're about to tell the, let me start over again. Do you swear that the evidence you're about to present is the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Witnesses are sworn.
Thank you, Mr. Chairman. The resumes of the witnesses were collectively submitted as part of Exhibit A. If asked, each would confirm the information contained in the respective resumes are true and correct. Ms. Womack will be a fact witness only. Messrs. Horner and Cotton have been previously recognized as experts in geology and petroleum and reservoir engineering, respectively, by the board. Presuming the division has no objection, we again request that they be so recognized as experts in those respective fields for purposes of this cause.
No objections from the division.
Okay, board, do you have any issues with the experts? Okay, please go ahead, Mr. McDonald.
Thank you, Mr. Chairman. And as you noted, the resume of Mr. Shea Atkins was also submitted as part of Exhibit A, but he will not be testifying, and consequently, there will be no need to admit his resume into evidence as part of Exhibit A.
Okay.
And finally, as is the practice here, we will be moving forward admission of our exhibits at the end of our presentation in chief.
Yes.
Members of the board, Uinta Wax is before you today seeking approval of a three-part request for development of lands within Township 3 South, Range 1 East in Uinta County. First, Uinta Wax seeks partial amendment of the board's orders entered in cause numbers 131-151 and 470-03 to expand the stratigraphic definition of the formation space to include additional anticipated productive zones of the Green River Formation above the TGR 3 marker. And as similar as the last matter, that would be up to the top of the mahogany bench. The board may recall it recently granted similar relief as to sections 3 and 10 of this township, but limited to 10,000-foot wells back in February and cause number 47025. This request expands those additional zones to all the lands within Township 3 South, 1 East, and is to all overlapping drilling units therein. Secondly, Uinta Wax seeks establishment of overlapping 3-sectional stand-up drilling units for 15,000 horizontal wells throughout the township. As the board is aware, these 15,000-foot wells are now the trend throughout the basin, and the board recently established sections 21, 28, and 33 of this township as a 15,000-foot drilling unit in the 470-24 order. Uinta Wax seeks authorization to drill up to 36 combined 10,000 and 15,000 foot wells combined on the existing drilling units established under the 131-151 order, and the requested drilling units with heel-toe setbacks of 100 feet and perpendicular setbacks of 330 feet and the other standard caveats that you're used to on these mortars. Mm-hmm. There are several existing wells either upon or which penetrate these lands under the board's orders in cause numbers 131-151, 470-03, 470-12, and 470-24. Because the requested drilling units will be overlapping, production allocation for those existing wells will remain on the current drilling unit basis under those orders. However, Uinta Wax seeks no inner well setbacks for these existing wells for the same reasons and justifications that the board found in several recent orders, including the 470-24 order. Namely, elimination of those setbacks generally benefits rather than harms the correlative rights of the owners in those existing wells. True and correct copies of the 131-151, 470-03, and 470-24 orders were collectively submitted as Exhibit B in this cause. Finally, Uinta Wax seeks establishment of associated drilling unit boundary well drilling units within the township with the standard caveats. In that regard, I do need to verbally modify the request for agency action at this time. Specifically, the request only specifically identified 6 drilling unit boundary well drilling units, but inadvertently failed to identify additional 4 internal drilling unit boundary wells, which are depicted on Exhibit G2, which we will be showing you. I would move to amend the request to also include approval of these 4 additional drilling unit boundary wells accordingly. It should be noted that notice was provided to all the production interest owners within the township, and there was no objections raised to any drilling unit boundary well drilling units.
Division?
Yeah, no objections.
No objections, okay. Board, any questions on that? Okay, proceed.
Is that granted then?
Yeah.
Thank you. The board has jurisdiction over this matter pursuant to Utah Code Sections 40-6-5, subparagraph 3B, and 40-6-6. Notice was sent via regular mail to all production interest owners within the affected drilling units, and to the school and institutional trust lands administration due to the state mineral ownership, and also to the Bureau of Indian Affairs, the Vernal Field Office of the Bureau of Land Management, and the Ute Tribe and Ute Distribution Corporation due to the tribal and allotted Indian mineral ownership throughout. These mailings were sent to the parties at their last addresses disclosed by the relevant agency records and the Uintah County Realty records, as well as Uintah Wax's internal records. The record will also reflect the notice was duly published in the Salt Lake Tribune on May 3rd and in the Vernal Express and Uintah Basin Standard on May 6th. On May 11th, the division timely filed a response to the request stating it does not oppose to the granting of the relief requested, presuming Uintah Wax satisfies its burden of proof at this hearing, as today's testimony will reflect Uintah Wax will sustain that burden. No other objections or responses were received. With that, I'll commence my examination of Ms. Womack. Ms. Womack, would you please state your name and business address for the record?
Yes, sir. Whitney Womack, 6000 Western Place, Suite 1000, Fort Worth, Texas, 76107.
What's your current position with Uintah Wax, and how does it relate to these the lands at issue today?
I'm a landman with Uintah Wax, and I oversee the lands at issue.
All right, and would you please state for the record the corporate and bonding status of Uintah Wax?
Yes, sir. Uintah Wax Operating is a Delaware Limited Liability Corporation in good standing with its principal place of business in Fort Worth, Texas. Uintah Wax Operating is duly authorized to conduct business in the state of Utah and is fully bonded with all relevant state of Utah and federal agencies. It is a designated operator on behalf of Uintah Wax LLC.
Ms. Womack, I'm going to direct your attention to Exhibits C through G. They're shown on the PowerPoint here. Also, I believe you have hard copies in front of you. Do you recognize these exhibits?
Yes, sir.
Were they prepared by you or Uintah Wax personnel with your review and input?
Yes, sir.
Turning your attention now to Exhibit C, would you please explain to the board what this shows?
Exhibit C is the regional locator map. It's the township at issue. It's outlined in red, and it's located approximately 3 miles due south of Fort Duchesne and due west of Ranlette and south of Highway 40.
Now turning your attention to Exhibit D, these are 4-page exhibits starting with D1.
Yes, sir. D1 in this exhibit, the focus is on 131 and 151 and 470-03 orders, which covered the entire town, covered the whole township. This slide does mistakenly includes 131-139 order, which was vacated by the 470-03 order.
Now D2.
This exhibit shows the orders where requested modification of the strat definitions were to include the mahogany bench, which has already been approved.
And noting that sections 3 and 10 as to 10K wells is within this township has already been approved for that extension. Now turning to D3.
This exhibit includes 470-24 order establishing sections 21, 28, and 33 as an existing 15K DSU.
And finally D4.
D4 exhibits the orders where no inner well setback from existing wells has already been approved.
All right, now turning your attention to Exhibit E, would you please explain to the board what this shows?
Exhibit E is a plat reflecting all of the existing wells within the township. And to note here, production allocation for all these wells will remain on their current basis. The requested DSUs will be overlapping.
Now Exhibit F, would you please explain what this shows?
Sure. Exhibit F shows the plats of the requested 15K well DSUs and a breakdown of the mineral ownership. The mineral ownership is mainly fee and tribal with very little state. Uintah Wax is the clear majority working interest owner throughout the township, and the third-party lessees have previously signed election letters approving Uintah Wax as the operator.
All right, now turning to Exhibit G. This is a 3-page plat starting with Exhibit G1.
Yes. Exhibit G1 is the 6 internal drilling unit boundary well DSUs that are described in the RA.
And G2, this is referring to the amendment that we made this morning that the board has granted. Can you please explain what this shows?
Yes, as you mentioned that you had made a motion earlier to amend this, and these are the 4 overlapping drilling unit boundary well DSUs that were inadvertently omitted from the RAA.
And finally, Exhibit G3.
G3 is a plat that is simply combining exhibits G1 and G2.
All right, now turning your attention to the certificate of service, you should have a hard copy in front of you. This is a pleading that's already on file that was prepared by my office. Do you recognize the names and addresses shown on that certificate?
Yes, sir.
And who are those parties?
We notified all production interest owners in the affected drilling units within the township, as well as Sitla, the Ute tribe, and the UDC, and the federal agencies with jurisdiction over the Indian oil and gas.
And how were those names and addresses compiled?
They were compiled with our Uinta Wax's internal land records, including title opinions, a search of Sitla, BIA, and Uinta County records prior to filing the RA by our contracted land service.
All right, and for the board's notification, again, because of the amount of parties, it was sent regular mail, not certified mail, so there's no Exhibit Z in this one. With that, Mr. Chairman, that concludes my examination of Ms. Womack.
Okay. Division?
Thank
Questions
you.
for Ms. Womack?
Ms. Womack, so we just talked about certificate of service. I'd just like to get confirmation. Have you heard back from any of these parties with any comments or objections?
No, sir.
All right. Thank you. No additional questions.
Okay. Board, any questions of Ms. Womack? Seeing none, proceed.
Thank you, Mr. Chairman. With that, I'll commence my examination. Mr. Horner?
Yep.
Mr. Horner, would you please state your name and business address for the record?
Robbie Horner, 6,000 Western Place, Suite 1000, Fort Worth, Texas, 76107.
And what's your current position with Uinta Wax, and how does it relate to the lands at issue?
I'm a senior geologist with Uinta Wax over the lands at subject.
All right, turning your attention to Exhibits H through J shown on the PowerPoint. I believe you have hard copies in front of you as well. Do you recognize those exhibits?
Yep.
Were they prepared by you or Uinta Wax personnel with your review and input?
Yes, sir.
Turning your attention to Exhibit H, would you please explain to the board what this shows?
This is the same type log that Mr. Atkins just showed, showing the intervals that we are interested in adding to.
And turning your attention now to Exhibit I, would you please explain what this shows and its significance?
Yeah, on the left is the Brotherson well, which has historically been what has been utilized for the stratigraphic definitions within the basin, and on the right is the BAP well that we just showed you. It's much closer to the lands at subject. This was also shown in 470-25. There is a bit of a scale change between the two wells just because of the increased thickness as you go to the north and the west, but they're finding the same intervals.
All right, turning your attention now to Exhibit J, please explain the significance of this exhibit.
This is a cross-section across the lands at subject, just showing that the uniformity of requested modified space formations are favorable for continued horizontal development.
All right, so is it your expert opinion then that the expanded interval constitutes a common source of supply within the existing space formations and that the continuity thereof make the 15,000-foot wells attractive throughout the township?
Yes, sir.
All right, Mr. Chairman, that concludes my examination of Mr. Horner.
Division, any questions?
Division has no questions, Mr. Horner.
Okay.
Thank you.
Board, do you have any questions from Mr. Horner? Seeing none, go ahead and proceed, Mr. McDonald.
Thank you, Mr. Chairman. With that, I'll commence my examination. Mr. Cotton. Mr. Cotton, would you please state your name and business address for the record?
Taylor Cotton, 6,000 Western Place, Suite 1000, Fort Worth, Texas, 76107.
And what is your current position with Uinta Wax, and how does it relate to the lands at issue today?
I'm the reservoir engineer for 3 South 1E.
All right, turning your attention to what have been marked as exhibits K through N, shown on the PowerPoint, and I believe you have hard copies as well. Whoop. Do you recognize these exhibits?
Yes,
And were they prepared by you or UNOX personnel with your review and input?
they were.
All right, turning your attention to Exhibit K, this is a two-page exhibit starting with K1. Please explain what this shows.
So this is an example of the 10K DSU showing the 330-foot setbacks, which allows for the drilling unit boundary wells, proper placement of the drilling unit boundary wells and to allow for drifting.
And K2.
The same thing, but for the 15K DSUs.
And again, the 330-foot buffer along the boundary line is to account for potential drifting?
That's correct.
All right. Turning your attention now to Exhibit L, please explain what this shows.
This depicts the potential 10K and 15K well development in each member of the requested modified space formations, especially the mahogany bench. And it shows up to a combined 36 10K and 15K wells in a wine rack formation.
Okay, now turning your attention to Exhibit M. This is I believe it's a four-page exhibit, starting with Exhibit M1.
So M1 is a map showing the location of the following 3 wells, which are all examples of wells that had an uptick in production from offset fracs.
All right, and turning to M2.
So M2 is the first well. I'll kind of annotate this a little bit. The green rectangles with the black outlines shows the time when the offset frac occurred. The green line, the green points rather show oil production, and as you can see, there's an uptick in production after the offset frac.
All right, M3.
Same thing going on, just different well nearby.
And finally, M4.
And M4 is just another example of a well that shows the same uptick in production.
And these exhibits were generally the same ones that were shown in the 470-24 order, is that correct? About that the board approved the no interwell setbacks, correct?
That's correct.
All right, now turning your attention to Exhibit N, please explain what this shows.
Yeah, I won't quote all the dollars and numbers, but the 2 main takeaways from this are that drilling the extra long horizontal wells provides better individual well returns by lowering the cost per foot of development while maintaining recovery per foot. And then that also the drilling of extra long horizontal wells allows for reduced surface disturbance while still efficiently developing the resource.
All right, is it your expert opinion then that the drilling of up to 36 10,000 and 15,000 foots combines in the drilling units are necessary to recover additional resources that would otherwise be left in the ground?
Yes.
Is it also your expert opinion that these wells will allow for additional greater recovery of natural resources with associated greater economic benefits and without adverse impact on adjacent correlative rights and without waste?
Yes.
Finally, is it your expert opinion that the elimination of the interwell setbacks between existing wells and new 15,000-foot wells in general benefits rather than harms the correlative rights of the owners in those existing wells and is consistent with practices in the UN and other analogous basins?
Yes.
All right, Mr. Chairman, that concludes my examination, Mr. Cotton.
Okay, division, any questions? Mr. Cotton.
Thank you. The division does not have questions for Mr. Cotton.
Okay, board, do you have any questions of Mr. Cotton? Okay, just one comment, Mr. Cotton. I mean, these, your Exhibit M is, they're all semi-log plots, and that's very significant increases in production that happened at that point in time. So that's encouraging to see that happen. Okay, thank you. Go ahead, Mr. McDonald.
Thank you, Mr. Chairman. With that, that concludes our presentation in chief. At this time, I would move for admission of Exhibit A without Mr. Atkins' resume and Exhibits B through N inclusive.
No objections from the division.
Okay, we got that, and we will remove Mr. Atkins, or I don't know if it's necessary, but we'll take care of that.
All right.
All right.
With that, I'll just wait until the division statement, and then I'll just make a quick closing.
Okay.
Thank you. As indicated, the division filed a notice of non-opposition in this request. The division reviewed the filings and the associated exhibits. We listened to the testimony here today, and the division has no opposition to granting this request. Thank you.
Great. Board, do we have any further comments, questions, need for deliberation? Seeing none, I'll entertain a motion.
I'll make a motion that we approve the request for agency action as presented.
Okay. Okay, it's been, the motion's been made to approve the request for agency action, but you're going to
With the
an
amendment. With the amendment.
Okay, is that understood, everybody?
Yeah.
There is an amendment to the, okay. All those in favor say aye.
Aye.
Any opposed? Hearing none, it's unanimous. If you could please, next week, with the amendment to the request for agency action, take care of that.
Certainly. Thank you, members of the board, and particularly for the opportunity for the witnesses to appear virtually.
Oh, yeah. Yes, sir. Okay, thank you. All right. Mr. Haynes, you're on the run. Okay, so is there any other board business that we want to conduct at this point in time, or anything people need? With that, entertain a motion to adjourn.
I move that we adjourn.
Motion's been made to adjourn. Any second? Second. All those in favor say aye. Aye. Okay, we are adjourned. We are off the record. Thank you.